My lord, extreme urgent, my lord. That's why I have come before the lordships. That is the matter is petitioner is a 78 years old lady. She is a lecturer for the Calcutta University. She retired from 2014. Till now, she has not got the pension, my lord. I came before the Honorable High Court. Justice Ritoboto direct the DPI to take a decision. DPI has passed an order. I have no authority. It is the finance department. That's why her claim has been rejected. My matter is appearing. Lord, I had presentation slip. I mentioned that is indicate that it's a pension matter. Despite the matter is appearing others motion item number 119. Lord. Kindly, otherwise she will die. Lord. She will not get any.
190 in the combined list?
No.
Today's list?
Other motions. 90. Let the matter under the caption. Because she deserved to get the pension, Lord. At any moment, she can die, Lord.
190?
Yes, Lord. Shipra Chakraborty.
আজকে টেলিরিসে তো ট্রান্সফার ম্যাটার দেখতে পাচ্ছি
190
only short for some
contempt matter 190
190 নয় দিদি আমার ম্যাটার 190 না 190 কন্টেম্প ম্যাটার
আরে কত টাকা লাগবে বাবা
কন্টেম্প আমার ম্যাটার
আরে পরে
yes
yes ma'am 119
119 119
119
yes
Shipra Chakraborty.
Yes, ma'am.
It is appearing under the heading
Others.
Motion Others.
Yes.
All right. Next week it will appear as under the heading Urgent Motion.
I'm getting
119. And give notice to the other side, all the parties.
My lord.
Number 353. He has declared one of the My lord has told the citizen the order of the day in respect of all of
What do you want?
And the content. Or I have some notice of personal option for that. Such appearing.
Are you aware who's your other side? It is appearing for the first time.
No,
second time. So you do not know who is appearing. Which item you said? 353. Next week, put it in the application top. 353. All right.
Well, item number 78, my lord. Item number 78, I am for the petitioner. It is a pension matter, my lord. If your lordship, all on a sudden they have stopped my pension, my lord.
78, it is there, very fairly at the top.
No, my lord, I am not getting pension last 2 months.
Done. Just wait.
Well, another mentioning, my lord. My lord, this is appearing as monthly list, item number 1900.
Monthly list I will not accept.
My lord, I am paying for upgradation, my lord.
No, sorry. Pension matters will be taken up. Just wait. I will.
Wrote a letter unless you deposit the 4,30,000, your pension price will not increase. So this is the happening melody. I only am paying melody admissible amount. Melody whatever admissible amount, they let them release this. Otherwise, melody they are suffering melody after retirement melody.
They means how many are there? One petitioner.
Melody, all of them melody 31st May 2025. They are not getting paid. Only 3 are mentioning. 2 melody appearing in the monthly list and another melody new motion.
The monthly list matters are there in the pension bundle.
No, another melody 1 melody 401 under heading pension. Another melody 1.
The pension bundle will be upgraded.
65 melody not under the heading pension.
The pension matters will be taken up on a day fixed. So do not mention those matters.
This is my lord, the others matters.
দেখুন তো others matters ওটাকে urgent motion করে দিন।
My lord,
And this is the new one, my lord, I am filing today. My lord,
File it in the department, it will be seen what is to be done.
my lord,
But there is no number.
I am filing today, my lord.
Then how can you get without the number? What is the use of mention?
This is the my lord, today.
File it, then we will see.
my lord,
Contempt application, lordship petitioner is a handicapped person and he is financially very weak. Lordship, private respondents are making illegal construction in his place. In the previous order, lordship has directed the alleged contempt of his KMC lordship here to serve the notice to the private respondent and made a hearing with the parties and written.
KMC?
KMC is the alleged contempt. No more has been done. Lordship, kindly fix a date, lordship.
Who is your other side?
Side Mr. Ochito Banerjee, Advocate Ochito Banerjee is appearing on behalf of KMC.
All right. Today you bring him after recess. I'll see what is to be done.
Well, with regard to item number 226, my lord, this is the 8th time your lordship directed to comply your lordship's order for removal of the my lord, the garbage which has been my lord, kept in front of my ingress.
Removal of the
After demolition, the all articles which has been kept in ingress and egress. 8 times your lordship directed Mr. Season 9 advocate appear on behalf of the KMC, undertake before your lordship within 2 weeks they will remove all the articles. Till this date, my lord,
bring your other side. I'll see.
my lord, the 226. Kindly note it, my lord. I will bring.
You bring. I'll see.
Number 8267 of 2025 for inclusion in the list.
Is today the day for inclusion?
No, my senior just tell me to.
You listen to your senior, but look at the list also. All right. There is a day fixed for inclusion. Come on that date, it will be included.
my lord,
All right.
my lord, as regards item number, my lord, 24 of the monthly list, my lord, what happened? I have got the information that the counseling of the upper primary is going to take place from 21 to 30th. My lord, on that day, my lord, there was a my lord, resolution. So my matter has been, my lord, passed on. My lord, I was present, but no other side.
How can that be? You were present. I have taken up all matters where parties were present.
My lord,
And
my lord,
I didn't find you here.
my lord, along with my lord, junior, my lord,
Yes, so you were not here because I didn't find you. And any matter which has been mentioned, this upper primary counseling I have accepted. Not a single one has been refused. Yes.
My lord, you remember yesterday, my lord, matter is taken up, my lord. The petitioner was get up regarding upper primary. The petitioner was get 77 marks. In this state petition, my lord, the petitioner get 80 marks, and the petition is SC category. But the petitioner did not get any intimation letter and any communication from the department, my lord. Now, my lord, seeking leave.
Wait,
filed
no.
My
You
lord,
file it in the department. Let
my
us
lord,
see what
kindly,
will
my lord,
happen. Because
counseling
though
process is
interview is going on in respect of the contempt matters, you file it in the
my lord,
department, I'll see.
petitioner.
No, sorry.
I have your ladyship's kind leave to mention item number 129 of your ladyship's days list. But the urgency that I have seeking for your lordship,
Which heading is it
my lord,
appearing?
it's new. My lord, the urgency is, my lord, the petitioner is a first year MBBS student. My lord, your lordship is aware, my lord, on the first professional examination are being taken on 4 occasions. 4 times a candidate can sit for that examination to come over the first year and go for the second year. But here in this case, my lord, the 4th attempt was made by the petitioner. Only one in the subject of biochemistry, she scored 5 marks less, for which she was 5 marks less, my lord. She opted for review. 33 marks was, my lord, lowered down, and the entire, my lord, career has been lost, my lord. She cannot, my lord. My lord, I have challenged the re-evaluation process. My lord, it is not there in the rules that such a, my lord, exorbitant marks could be, my lord, slashed down to bring the petitioner out of the zone of consideration, my lord.
Even if she was 5 marks short,
My lord.
she would have faced the same fate. It hardly matters whether it is 33, 35 or anything.
My lord, I have challenged just for, my lord, I have challenged the evaluation process, my lord.
Occasions you got a chance, let it remain.
Just one subject, my lord, 5 marks was short.
Sorry, sir. Yes.
Malad, petitioner was appointed, Malad, as a library peon, Malad.
I do not want to know the merits of the
Malad,
matter.
salary has been stopped, Malad.
Yes.
Malad, and petitioner was allowed to join. She was terminated earlier, Malad. She was allowed to join, but my salary has been stopped, Malad. Petitioner is admitted in the hospital, Malad, and she is having a minor daughter, Malad, suffering, Malad. That's why, Malad.
And the petitioner is in the hospital, and how will she get her salary if she doesn't attend the school?
Malad, she is now, Malad, admitted in the hospital, but salary has been stopped, Malad, since April, Malad. That's why, Malad, I'm harping, Malad.
And in July, you all on a sudden you think that
No,
the
Malad, I'm
urgency has
mentioning, Malad, the matter regularly, Malad, but the matter is not, Malad. It is appearing as item number 1844 of the monthly list, Malad.
So today is not the day for mentioning upgradation of monthly list matters.
Malad, I have already
Then
mentioned
your
the
slip is
matter.
there. Just wait. Yes.
Item number 1536 is a group 6 matter, my lord.
1533.
1536, my lord.
1536 released. Group 6.
My lord, I am seeking for inclusion of a matter WPO number 131 of 2026. My lord, the matter is regarding
I do not want to know the regarding what. When did you
the
file it?
urgency is that the
When did you file it?
ma'am, last I think so, ma'am.
Think so.
This
Inquire.
my lord, this year May, I suppose.
Did it appear anytime?
No, ma'am.
Never?
No, my lord.
It will appear. Do not worry. Call the list, please.
Your Lordship can hear him, but I have to come back with instructions.
The hearing. It's a court
No, no.
application, I can see.
It's never please,
Kindly takes the list of dates. This is
Ma'am,
very important
without
for the
instruction
entire
today,
purpose.
Milord.
Oh,
Of course.
you are without instruction.
No. The writ petition apparently,
Calcutta University.
Yes, Milord.
the writ petition apparently, Milord, it is my mistake, Milord. It's short of certain pleadings. Milord, kindly sees, Milord, the list of dates. What is the issue
Give
here?
a copy to him.
I've given.
Yeah, given.
Yes, please.
Milord, the petitioner was admitted for BSc Honours in Psychology, Milord, in 2023. Milord, thereafter, Milord, the first semester, Milord, here kindly bears, Milord, the even semesters are held in April, in the middle of the year, the odd semester, end of the year. I was wrong, Milord. Odd semesters, middle of the year, even semesters, end of the year.
Anyway, middle and
Semester
end.
1 conducted in April 2024.
Hmm.
Milord, the results were published sometime in July 2024. She was reported against. Milord, the Board of Discipline ultimately, Milord, found the petitioner guilty and imposed this penalty on 5th of August 2024, serial number 7. Now, Milord, the university, despite this debarment, Milord, what happened is the petitioner was permitted to sit for the semester 2 examination.
By mistake?
Milord, for whatever reasons, Milord, semester 2 examinations, she was permitted to take, Milord, in the year 2024. The results remained not published. Consequently, Milord,
She filed a writ petition.
she filed a writ petition, coordinate bench of your Lordship's court. That order, your Lordship will be pleased to find, it's a part of the writ petition.
Semester result to be declared after expiry of
Of the
debarment.
debarment, Milord, then petitioner be enrolled as in semester 3 and petitioner permitted to appear in semester 4 with regular match. Petitioner permitted to appear in semester 1 examination simultaneously with 3. Now, Milord, today the position factually is she has been permitted to appear in 1 and 3. She has completed 2 and 4. She has also sat for 6.
And to the results.
All results published. She has also sat for 6 after pursuing, Milord, the courses. She also pursued the 5th semester courses, but Milord, 3 examinations at a time, the university did not permit her. 1, 3, and 5 together. The university did not permit her. She appeared in the 6th semester, cleared 6th semester. Today, factually, she is supposed to be in the 7th semester. Now, Milord, there is an impediment. One of the annexures, Milord, to the writ petition, I shall, Milord, show the page. Milord, a latest decision has come, which, Milord, obliges the petitioner to clear 1 to 6.
All. Then
For
only
7.
7.
For 7. Milord, that is the only difficulty. Milord, if today I am to clear 5,
I am to clear 5.
6 months.
This, my lord, I lose. Virtually, I lose a year because, my lord, 5 again will take place next year. 7 again will take next. Now, what I was essentially seeking from your lordship, my lord, as a special case, my lord, if your lordship, my lord, because previously the rules were different. Previously, the rules obliged a person or candidate to clear the examination with 30%, my lord, aggregate in all the papers. But that rules underwent a change not very recently. I mean, today the factual position subject to correction by my learned friend, what I was essentially seeking, Lord, that if some departure can be made, if this candidate, Lord, for this candidate, if 5, she is going to pursue 7, she is not being permitted to take classes for 7 classes are, she has not been permitted to take admission in the 7th semester. Now, my lord, if 7 semesters she is permitted to pursue, and along with 7, she is permitted to take the 5th semester examination. That is the only thing, my lord, for which I have come to your lordship. Nothing. It's essentially, my lord, seeking mercy from the court.
Tell me one thing, when the candidate was debarred,
Yes.
debarred from appearing in the examination, was the candidate permitted to participate in the regular classes?
Yes.
Only the examination portion, she was
Now, my lord,
debarred.
what happened is, despite this debarment order, rightly, wrongly, my lord, I'm saying, my lord, it's my mistake, it's my misfortune. I am not blaming the university for a moment. I'm not blaming the university for a moment. My lord, the writ petition essentially is seeking, my lord, some leeway, my lord, in order to protect the career of this student, my lord.
But there the
rules stand in the way.
The conduct of the student is also not very good.
I don't support. My lord, I cannot subscribe to, my lord, whatever has happened.
Because
and, my lord, the essentially, my lord, it is not a case of cheating. It's essentially
Let
I'm
us
going into that.
not go into that.
I am not going into that.
That is the reason the court also did not inquire what was the
I am
matter
also
about.
not going into that, my lord. Whatever be the, my lord, she was reported against, there is no
Yes.
dispute regarding that.
Right.
Well, the difficulty is, beloved, it is not that the university is not allowing.
The
Difficulty
rules.
it is that the rules are not.
Yes, yes.
I'm also saying.
Beloved, may I say this, beloved?
Hmm.
Further, beloved, difficulty is, beloved, 7th is the subject to correction is the honors
Yes.
course. So, in order to be entitled to honors,
You have to
clear all the
complete
semesters.
subjects.
That is, beloved, the
Problem.
that is the rule for all. Now, to what extent, Milord, I believe, Milord, we are not in such rush that I cannot sit with the controller and, Milord, try to see if there can be, since there was an order, there can be some leverage in for the petitioner. May I come back next week, Milord? Wednesday, Thursday, something like that. Any day.
Anytime your lordship.
Wednesday, I'll prefer instead of a Thursday.
Kindly, Milord.
And what are the averments you say you've missed?
The factual details. The dates.
Not there in the
I'll agree to because, Milord, in the last round, Milord, we have tried to help out the petitioner.
No, there is a, I do not
yes,
say the reason, Milord. There is an otherwise reason. It's not something, Milord, essentially a professional part. There's some other angle to it. I'm not going into that. Milord, it's my mistake, Milord. I should have checked it, Milord. Kindly permit me to use a supplementary affidavit. I'll incorporate this entire thing, Milord, by way of a PD.
Kindly do that, Milord.
Also, Milord, I'll serve it by tomorrow.
No problem. Please
by tomorrow.
Subject to.
Honored advocate for the petitioner seeks leave to file a supplementary affidavit.
I'm taking lordship.
Incorporating facts and documents which have been inadvertently missed out in the writ petition and which will be essential for effective adjudication of the instant list. Stop. Heard the submission made on behalf of the petitioner. Stop. The petitioner seeks for a direction for taking admission in the 7th semester examination. Stop. She is yet to clear a couple of earlier semester examinations.
Semester only is pending, Milord, subject to. Only the fifth one is.
Only fifth. আচ্ছা তাহলে fifth.
তাই তো?
Yet to clear the fifth semester examination. Stop. The rules of the university does not permit admission in the 7th semester till all the semesters up to semester 6 is cleared. Stop. Paragraph.
It will be my lord's pleasure not to put in this observation for the timing.
You do not want this to go?
At this juncture, my lord, I'll try to, my lord, sincerely try to, my lord,
আচ্ছা ওটাকে তাহলে বাদ দিন।
kindly, my lord.
লিখুন, প্রেয়ারটা লিখুন। প্রেয়ারটা বললেন তো? To allow the learned advocate representing the university to revert with instruction in the matter released on 29th.
We remain grateful, my lord.
Great. IISWBM.
Actually, my senior.
Microphone.
Actually, my senior got stuck in traffic. So, may I ask for a passover, ma'am?
No, there is no scope for a passover in the original side matters. Why are
She
you
will
not
be there
prepared?
in 10 minutes.
Why are you not prepared? Yes, please.
Yes, my lord. My lord, the petitioner, my lord, was appointed as a typist in the institute.
Typist.
My lord. Thereafter, she was given promotion.
Hmm.
Now, lord, a decision was taken to introduce a VRS scheme in 2020, April 2023. My lord, she being having medical grounds, she opted for VRS, and that was accepted, and she was allowed to be released prematurely from service, my lord, on the basis of that VRS. My lord, dues were paid, but only the VRS dues, which are additional, those were not paid, was told that there is a signatory issue going on.
There is a
Signatory issue. But in the meantime, my lord, there was some writ petitions filed between the board of director and board of governor. That they have disclosed in the affidavit in opposition.
What has that got to do with the employee?
Now they say, my lord, that there is no VRS scheme at all.
No VRS?
No VRS.
How could you be permitted to retire in that case?
They say you have been allowed to retire prematurely, but not on VRS. But there are documents which says that your VRS dues.
Is there a VRS scheme?
My lord, there is VRS scheme.
Show, please.
Now kindly comes to page 18 first. Page 19 is the relevant portion. This is a part of the meeting, my lord, where the VRS scheme was introduced. Revision has been taken to introduce VRS scheme.
Yes, thereafter?
Thereafter, my lord, the petitioner opted for in page
No, 19 is only a proposal.
Proposal.
Where is the scheme?
My lord, kindly comes to no, yes. Kindly comes to page 29 once, my lord. Page 27, right? Page 27 is the scheme and 29.
27 is the scheme.
27. There, my lord, they release me.
Where is the scheme? Show me the scheme as
My
per
lord, page
the
20
VRS.
kindly comes to page 25. These is the minutes, my
As
lord.
per the VRS rules. Where are the rules?
My lord, page 25, my lord. This is the minutes of the meeting where they formulate the
Yes,
VRS
minutes of
scheme.
the meeting, the VRS scheme. But then has this been approved by the board of directors?
But I have been allowed to release on
This
VRS.
is held on 28th of June 2024. Yours is the 5th of July 2024. Uh, 28th of June. What are the terms and conditions of the VRS scheme? There must be something.
Well, page 25 is the terms.
All right. VRS scheme, the person who has completed 20 years of qualifying service.
And my prayer, my lord, for VRS, my lord, is at page 23, which says, my lord, principally approved and considered her case.
No, what are the benefits he will get?
But this is page 25.
The salary for VRS shall be calculated on the basis of 30 days a month. Cash value, full share. How much is the difference if you take premature retirement and VRS? Possibly the VRS salary will.
Yes, ma'am. I have been paid provident fund, gratuity, leave encashment. Only the VRS salary portion, my lord, they say the entitled VRS benefit due to you will be transferred accordingly to your account immediately once the signatory issue is resolved. That is at page 29.
Signatory issue, I do not follow. They have a problem with signing.
Well, they had a problem with signing, my lord, that will appear, my lord, from an interim order passed by this court at page 25 of the affidavit in opposition. Yeah, my lord, as an interim arrangement, my lord, the court granted the authority to sign at page 26. This is probably the signatory issue, and this has been disclosed in the opposition, my lord. Treasurer representing the respondents may be authorized to sign all checks, and this is the signatory issue.
What happened to this matter?
Ultimately, my lord, when this is before the division bench, it was withdrawn.
This is a contempt.
But it was filed before the single bench. The single bench held that there was a decision.
Appeal was filed.
He challenged.
Order was passed. Then
Appeal was withdrawn, my lord. Appeal was dismissed.
Appeal was withdrawn. That means the order of the single bench stands.
Yes.
What did the single bench say?
Well, a single bench said that the decision dated 30th of May 2017 has been set aside. That is at kindly comes to single bench order matter at page 15 of the affidavit in opposition. The 30th of May 2017 থেকে আমাদের একটা charge document.
This is completely between the management, the board of trustees, the board of governors and everything. Nothing to do with the employees and nothing of this sort.
But this is the ground taken in the affidavit in opposition that due to this, the VRS scheme, we are not recognizing the VRS scheme. There is no VRS scheme. After I have been released from my service.
Please come. The petitioner has retired from service by availing the voluntary retirement scheme of IISWPM. Step. She has, however, not been paid the benefits under this scheme. Step. On the prayer of the learned advocate representing the respondents, hearing of the matter stands adjourned. I'm fixing it next week. Next Wednesday, 29th. Give your name. Your name put down. Don't put anybody else's name.
My lord, may I permit to mention a leave, my lord?
This is not the time to mention. Mentioning is over.
My lord, kindly, my lord.
Why?
My lord, this is a very urgent matter, my lord.
Why didn't you come at the time of mentioning? Who stopped you?
My lord, we came, but
My lord,
What is your learned friend saying from behind?
my lord, we have missed the urgent point, my lord.
You have
Missed the urgent point, my lord.
missed the urgent point? Where? When the matter will be taken up, you please plead.
My lord, today we have mentioned that leave, my lord, but we have missed the urgent point, my lord, because tomorrow is the counseling, my lord, because the petitioner didn't get the intimation letter, my lord.
Got the intimation letter means?
My lord, may I appraise this court, my lord? Because of that, my lord, the petitioner marks is higher. The School Service Commission never issued the speed post counseling letter. As per the rule, every candidate.
Is your name appearing in the list of
Yes,
candidates
yes, yes. Waiting. Yes,
for
yes.
counseling?
Yes,
No, my lord. That's why, my lord, I am aggrieved, my lord. My name is not featured in the list, which
Yes.
is ought to published tomorrow's list, my lord. Because of that, the less meritorious candidate got opportunity. Whereas I am a higher pedestal candidate, I got higher marks. Although there are no counseling letter issued to me till date, and not only that, my lord, there is a specific rule how counseling ought to conduct. The School Service Commission rule is very specific.
What?
Each and every
Which subject?
History, Bengali medium.
history, my lord. Tomorrow,
Ah.
my lord.
The counseling is to be held tomorrow?
Tomorrow, my lord. So, my lord, kindly keep it at 10:30, my lord.
No, no,
Tomorrow
10:30, I've got other matters. Let's keep it held.
Any time, my lord, the last counseling in English subject, although there was 82 seats, but 28 seats was vacant. The candidate not appeared, my lord. It will be kind enough, my lord. Kindly keep it tomorrow, any time, my lord. Any time, my lord.
What is the item number?
Leave to file, my lord.
No, my lord. It is a first time, my lord.
You want
Leave,
leave to
leave.
file?
Yes, yes.
Unusual leave into tomorrow urgent motion.
Grateful, my lord. Grateful, my lord. Grateful.
Serve the other side, please.
Yes, my lord. Yes, my lord.
About the communication for non-prosecution. And like this is their resolution. Because this is institution before your lordship, my lord.
Yes.
Their resolution.
Lordship, Mr. Shayan Banerjee is appearing on behalf of the university.
The institution was moving the writ petition represented by the assistant secretary, and now the institution wants to withdraw the writ petition. Why? The grievance has been redressed or what?
We are challenging non-granting of affiliation by the Baba Saheb Ambedkar University. My lord, for 24-25 for the my lord, session. Now, my lord, the session already passed, my lord. Now 26-27 is going on, and I have, my lord, quote from for affiliation for 26-27. Nothing in my writ petition now.
Then there is no cause of action.
My lord.
Come. Learned advocate for the petitioner submits that the cause of action for filing the writ petition does not survive at present. Stop. The petitioners have intimated their intention not to proceed with the writ petition any further. Stop. In view of the above, the writ petition stands dismissed as not pressed. The photocopy of the meeting resolution book and the communication by the one of the petitioners be written with the records. এটা ফেরত দিয়ে দিন. There is already a copy. Keep this. অন্য একটা আছে.
I don't know.
Government.
I am also for this.
Who is there for the petitioner in item number 2?
None appears probably for the petition. No one is appearing, madam.
And the matter was filed by obtaining leave.
Yes.
Sorry, my lord. I'm appearing for the petitioner, my lord. I'm very sorry.
What is the matter about?
My lord, the matter is, my lord, about, my lord, I prayed for disciplinary proceeding against certain teachers, my lord. My lord, I prepared a short list of dates, my lord, for your lordship.
Who are you?
My lord, I am, my lord, the father, my lord. My son was admitted in the said institution, my lord. I prepared a short list of dates for your lordship, my lord. My lord, what has happened on 4th January 2026, I have admitted my son to the particular institution, my lord, named Sharoda Shiksha Mandir, my lord. This particular institution, my lord, I've admitted my son who is 14 years old in class 9. I've paid all the amount, my lord, 20,000 rupees at the time of the admission. Thereafter, my lord, what happened, my lord, from 4th.
Is anybody there for the school? You are for the?
We are for the state.
Oh,
But
both are
I've
for the
given
state.
representation to the school also, by mail also.
Yes.
Thereafter, my lord, from what happened, my lord, from 4th January to 17th January, I was not allowed to meet my own son. In the
It's a
meantime,
boarding school.
it's a boarding school. Yes. Thereafter, my lord, what has happened, my lord, in the meantime, my son has called me, informing me about certain things happening in that particular school. My lord, I'll take your lordship, my lord, to the particular representation, my lord. My lord, kindly comes to represent page number 51 in detail, my lord. My lord, on 18th, I have rescued my son from the particular institution and I have brought him back home. My lord, page number 50, my lord, kindly consider this one. My lord, I am just reading the relevant paragraph where the allegations are. সেখানে মিশনের বড় ছাত্র মিশনের যারা রাত্রে সুষম স্যার ছাত্রদের হাতে বিড়ি খৈনি মুখে গুজে দেয় গুটকা বাচ্চাদের হাতে দেয় এবং বলে তোরা বিড়ি খাস না বললে মারা হয় দিলে ভিডিও করা হয় যদি তোমাদের মা বাবাকে বলিস বা জানাস তাহলে ভিডিওটা সকলকে দেখাবো স্কুলের ছাদ থেকে ফেলে দেবো দিস আর দ্য থ্রেট গিভেন বাই দ্য টিচার এভাবে শারীরিক ও মানসিক
School.
Yes, boys
It's a boys' school.
Boys' school.
All right.
And all it's happening with all the students, my lord. Videos are taken, my lord. এইভাবে শারীরিক ও
Who
মানসিক
takes the videos?
teachers and my lord, there are some senior students are also involved. Senior students are there. Principal is involved and my lord, 2 teachers. One teacher stays in the night in the hostel only with them. He is the person who is getting drunk, who is my lord, making the students stands, giving cigarette burn marks and everything. He is the main person and the principal is involved. We have informed the principal. What happens, my lord, principal, after everything, I have gone and I have informed the principal. After certain days, he calls me, he calls the father and tells my lord to my lord withdraw the particular case and with talks of settlement. No action was been taken, my lord. And where it is the responsibility of the principal when this kind of complaint regarding ragging is been made to take the first step, my lord. This is what, my lord, the statutory
Your
laws are saying.
complaint before the principal, where is it?
Yes, my lord.
Page 50 is to the OC.
OC, yes, my lord. Yes, my lord.
An FIR has been lodged.
FIR has been lodged after 1 month, my lord. After 1 month. That is why, my lord, I have handed your lordship the list of dates, my lord. Your lordship, it will be easier, my lord. My lord, written representation is page number 42.
Devabruta Roy, child under the orders of the child was under the CWC?
Yes, thereafter the CWC gave
What was the
notice.
requirement of the child to go to the CWC?
Because, my lord, the child, we have made representation regarding the things.
Where from was the child rescued?
Child was been rescued by the father. Notice thereafter was served to the petitioner's house. CWC.
Who rescued the child?
Father.
From where?
From the school.
No. How did the child go to the CWC?
Well, CWC served a notice after we informed them the allegations that has happened with my particular child. Thereafter, they served notice. We informed them.
The child was all along there with the father. Prior to getting admission in the school.
Prior to getting admission, he was with the father. Thereafter, when the child was been admitted from 4th January to 17th January, the child was in the hostel. 18th, the father went and rescued his son. After doing there was a verbal argument, my lord. Thereafter, I rescued my son with the teachers. When the father tried to inform them that this has happened, what is the condition of my son? I'll show the medical report.
But why will the CWC come in over here?
But I don't know. They have given
what
me
do you
notice.
mean to say you don't know?
Well, they have served me notice because they wanted to know about the welfare of my child.
Of child under the
Because my lord, the complaint against child abuse, probably because
You
of
are the father. Where is your wife? Where is the mother of the child?
mother, my lord, staying with me in my house, my lord.
She's there.
Yes.
Who approached the CWC? Did anybody approach the CWC? Are you aware? Is the state aware of any incident?
No.
What does the report say?
My lord, may I submit? Plain reading of this case and the annexed documents, medical documents, otherwise speaks about the mental condition of the child, because the child is taking not only antidepressant, other medicines which are evident from the
Yes.
report. So it suggests, probably, I am not sure about that, only investigation will conclude it. Probably the child is suffering from some mental disorder quite previously, prior to this incident. So whatever story, I am sorry, my lord, might be fact, might be story, but there is a probability that whatever he is telling to the police authority or the parents might be concocted, might be.
Yes, my lord.
And
Concocted. That is why the medical report is showing the burn injuries.
this is number one. Even I can contradict the medical report from this plain reading of the report, which is evident from the report itself. Because that it says that the injury which has sustained is due to fall. From the medical report, it is evident. You may even you may check, my lord.
No.
And may I hand over the report, my lord, of the police authority, which speaks, my lord. Kindly takes up page 3, second paragraph. Let there be a proper investigation. Even we want a proper investigation.
It is you who have to do it.
Yes, we are. We are doing an investigation. But they have filed this.
We means who is doing?
The police authority is doing an
No, let the investigation be done. What the police is doing, let the police do. From the district, is the DIS party? Yes.
Police
Let
is
the
doing a
DI
lot. After 1 month, they are registering the FIR.
Kindly see page 3. Second paragraph.
The school is a aided school? Is the school an aided school?
Aided school. Yes.
And where was the child studying prior to this? Where was the child studying prior to this?
Well, the local school, in his jurisdiction. Martirari, something high school, some high school, in his.
What was the requirement of shifting a child to this school, to a boarding school?
Because, the particular institution is a very well-reputed institution. Sharodama, the particular name suggests, it's a very well-reputed institution. We have given in the representation also, the father, thinking about the welfare of his child future, has admitted his son. Sharoda Mission, it's a very well-reputed institution.
And then nobody has complained. It is only you who has made this complaint.
Because,
it's a very well-reputed institution, isn't it?
But this is also a fact. This type of incidents, knows how they have been suppressed.
No, nobody knows. Who knows
there
what
are
is
other
going to
students
happen?
also. I can say this much. Medical reports, he's saying, oh, there are black marks. Medical reports.
Kindly takes to the medical report. Kindly, my lord, page 40. The medical report. Kindly sees. Not a single medicine about
The
burning.
petitioner claims.
How you will corroborate?
Burn injury? Cigarette marks are the burn injury.
The petitioner claims to be the father of a 14-year-old child who was studying in a residential school named Shikha Mandir. In Purva Bardhaman. Stop. The school is a government-aided school. Stop. The petitioner has made several allegations in the writ petition against the school authority and its principal and teachers. Stop. It has been submitted that some of the senior students of the school are also involved in ragging and other illegal activities. Stop. Paragraph. According to the petitioner, he was somehow able to rescue his child from the school. Stop. Complaint was lodged before the principal of the school as well as before the police authorities. But as no response has been taken, the instant writ petition has been filed. Stop paragraph. None represents the school. Where is the affidavit of service?
Yes, madam. Affidavit of service is here, madam.
Degi?
I've given mail representation also to them. Well, normally the state would only represent the school because it's a government aided school, madam. This is what I received.
Where is the? This is only
mail.
a mail.
Mail
But where is the
representation.
copy of the writ petition being served? It has the entire writ petition has been served through mail.
No, madam, no.
It's
This is
only
just
the
a
notice.
notice. Madam,
Then
I've
where's service?
madam, what I've received the information since they are the government aided school, the state will only represent. We have served the state everything. And by
Do
email.
not try to make out stories before the court.
No, madam.
The school is a party and you say that the state will represent. Why?
Madam, I'll serve, madam, if required. I'll serve it.
কি বললাম? না কেটে দিন. Copy of the writ petition has not been served upon the school. Stop paragraph. As there are serious allegations leveled against the school authority, the District Inspector of School Secondary Education Purva Bardhaman and the Superintendent of Police Purva Bardhaman are directed to cause separate inquiry, including spot inspection, to ascertain as to whether the allegations made by the petitioner in the writ petition are proper or not. Step. The aforesaid authorities shall obtain the statement from the students of the school, the teachers and the non-teaching staff at random and place the same before this court on the next date. Step. Let a copy of the writ petition also be served upon the school. Step. Released the matter for further consideration on 6th August 2026.
My lord, only one innocuous prayer, because within 6th August, if the entire asking and recording of witnesses, it can be done, because we will come.
Why it cannot be done?
Very well, my lord.
Why will you take so much time?
I leave before your lord.
Acha, arekta jinish. If any illegality is noticed by the aforesaid respondents, then prompt necessary steps shall be taken.
Grateful.
Grateful, my lord. I'll serve them, my lord. Very sorry, my lord. Grateful.
I do not see. Well, I am for the petition.
Number 125.
Group 6 বলছে
This is a serious matter, my lord. This is related to my lord, national eligibility come entrance test on the bridge. This year,
by the
by the National Testing Agency.
NTE, where is the representative of NTE? Anybody representing?
Lordship, my lord. Lordship.
You are there.
I
All right.
My lord, NTE had conducted this test. My lord, kindly come.
Who's for the state? You are for the state. And the Directorate of Medical Education, the state will be there. Chairman of the National Medical Council. Who will be there for the National Medical Council?
Service which definitely.
Union of India.
Me, my lord.
You are there for the Union of India.
India, my lord.
And the National Testing Agency also.
Testing agency.
And the National Medical Council also.
My
Six.
lord, there is some confusion, my lord.
Six National Medical Council, I do not know.
I am not representing.
All right, let's
Right.
see. Yes.
My case is simple, my lord. They have
They means who?
National Testing Council.
Alright.
They have conducted the test. If your lordship kindly come to paragraph 9 of the petition. Lordship will find that email dated 15/7/2026, the respondent National Testing Agency furnished to the petitioner a copy of her OMR answer sheet corresponding to application number such and roll number such. The said OMR sheet records that the petitioner was allotted the test booklet such, bearing test booklet code 80, and the petitioner states that in accordance with the instructions issued by the respondent authority, she had duly filed in all required particulars OMR answer sheets. Thereafter, Lordship kindly come to paragraph 11. Lordship will find out the breakup of the marks, how these are given. OMR answer sheet, the final answer key corresponding to test booklet code 80, the petitioner estimated she was entitled to secure 661 marks out of total 720. However, to the utter shock, the surprise, the petitioner, when the result of the NET UG 2026 exam was declared on 16/7/2026, the scorecard issued by the respondent authorities reflected that the petitioner had secured 289 marks out of 720 marks. Thereafter, Lordship have given the comparison in this paragraph only. Lordship will find out the question number, answer as per final answer tree, the numbers were given, answer as per OMR sheet, and marks. And calculations rule was, my lord, if someone does not attend, no negative marking. If he wrongly attends, then there will be negative marking, -1. And if he attends correctly, then 4. My lord, I have calculated it on the basis of the documents which were supplied by them. Now, Lordship, kindly come to the final answer key. It's in page 19. That analyzing above chart, it can be concluded that the total number of correct answers are 166 and total number of wrong answers are 5 and total number of unattended questions are 9, which brings the estimated score of 659. So I got almost 370 marks below the number which I was entitled to get. My lord, this is the case which I have. Now I have made the email to the authority. My lord, email is annexed in page 51. 52. And this is the wrong. Then I got, these are the receipt on 17 July. This I sent on 17 July, I have sent. So my lord, my grievance is that it has to be addressed. Now, this is a proof. Lordship, both the papers, the OMR sheet was given by them, answer keys were provided by them. Now, Lordship, I was considering this issue, whether this is an important issue today. My lord, the Honorable Allahabad High Court was dealing with such a case, my lord. And Honorable Justice Sinha was there, Arindam Sinha. My lord, his lordship was there. And in that writ petition, the only point was there was the fault on the part of the petitioner to put the correct inputs in on the paper. So the only thing they took up a point that there is no scope of re-evaluation, recalculation, but an interim order was passed in that matter, my lord. May I hand over a copy of that judgment?
No, here Your OMR is here, 49.
Yes. Page 47 and 49. Lordship, kindly come to.
47 is the answer key and 49 is your OMR.
Yes, madam.
Right?
Yes.
Let them come back once. The petitioner appeared in the NEET within bracket UG 2026. Stop. He alleges that he has not, that his OMR has not been properly evaluated. OMR sheet.
No, my lord, this is lady. Petitioner is the lady.
Actually, his answer sheet has not been properly evaluated. The final answer key published by the National Testing Agency and the answer sheet of the petitioner. Both are annexed to the writ petition. Stop paragraph. Learned advocate representing the respondent authority is directed to revert with positive instruction on the adjourned date. Tuesday, I keep it. Today is Thursday. You'll just look at it and say whether the marks is all right or not. It won't take much time.
Well, it's a proof given by them, so it can.
Yes.
Now it's
What
a
is
open
the
and shut
proof?
case, my lord. It's not a problem.
The final answer is also by you and the answer script is also yours. Just see it and say whether the marks have been rightly given or not.
Rightly
Nothing
given.
more.
But the only anxiety, my lord, if the counseling starts. I know
That is the reason I'm giving such short date. মঙ্গলবার হচ্ছে 28 তারিখ 28th. Bring written instruction.
Grateful, my lord.
For the petitioner, it is that matter that SLST, that 2 marks was deducted and she goes out of consideration. She was not called for. I've handed over your lordship's order also. My lord, I place the case first. My lord, kindly take page number.
How is the counseling going on?
My
Are you
lord,
getting candidates?
This subject is over.
Yesterday.
It was yesterday. Bioscience.
Bioscience is over.
Yes. So what I was suggesting, the other matter, which was heard day before yesterday, that has been kept on the 28th.
Yes.
That candidate came, counseling was done, etc. She is.
Are you all getting candidates? They are coming.
Yes.
All right.
So kindly keep this matter on the 28th also. I will come back with an instruction whether we still have vacancies left over, whether this candidate is eligible, and if so, if we are going to call for counseling, what would be a
Further
convenient
counseling.
My lord, I have one thing to submit.
I think I will
Very
come
specific.
to the 28th and
What my learned senior friend has submitted. Whether she is eligible as per the division bench's order. One, there is no doubt about her eligibility. Secondly, whether vacancies are there, it is also there in honorable division bench's order for 1,400 and odd. She is there. 14,052, paragraph 42 of the judgment of the honorable division bench. No, the question of eligibility does not come today.
The petitioner.
My lord, eligibility does not come today. It has been clarified by the honorable division bench.
To,
It's only the
no,
date
the
is to be
petitioner alleges. The
but today
petitioner
is-
alleges that she has not been she has illegally not been permitted to participate in the process of counseling
having higher
with respect of the bioscience within bracket UP.
for female category, OBCB.
Bioscience. UP na in the upper primary within bracket except physical education and work education recruitment process. Stop paragraph. Submission is that candidates with marks lesser than that of the petitioner have been permitted to appear in the counseling. Stop paragraph. It appears that the counseling for the aforesaid subject was taken on 22nd July. Stop paragraph. to allow the learned advocate representing the School Service Commission to revert with necessary instruction with regard to the fate of the counseling process in respect of the aforesaid subject. Release the matter on 28th of July.
Under the same heading, ma'am. Very good. But may just take moment of your lordship. I'm borrowing one moment. My lord, it has been fixed. There is no change of any credibility or eligibility of the
Order
candidate.
sheet ta fero diye din.
Yes, your lordship's order. I may take back.
In the
My
other
lord,
matter also, the court allowed us
No,
to
that
check
is
the
fine.
eligibility first
Not an
and
issue.
then
My lord, only
participate.
thing is that counseling is only choosing the schools. There is nothing left. Only choosing the schools. That much is left. That is my humble submission.
Yes, next.
Chalo. Great.
Item number 5.
I am in item number 5. I am appearing on behalf of the petitioner, my lord. This matter relating to my lord West Bengal Police Constable appointment, my lord. My lord, kindly, my lord, this matter along with another 5 matter which is released by the coordinate bench, my lord, fix the other matter tomorrow's at 3 p.m. my lord. It will be kind enough, my lord, kindly fix this matter along with my junior will hand it over another 5 matters which is, my lord, taken up earlier. That's why, my lord, coordinate bench release this 5 matter also. My lord, kindly take up this matter.
No, it is all right. But then why tomorrow?
Tomorrow, my lord, other matter, Chandan Dhara matter fixed at 3 p.m. tomorrow, my lord, for hearing. My lord. Yes, my lord. Kindly hand it over the Chandan Dhara order. My lord will remember this matter relating to, my lord, the
For
reservation.
hearing, no time has been fixed. No
Yes.
time fixed.
Oh, sorry.
For hearing.
Hearing,
Yes,
yes.
all right. Let
So,
this
my
matter
lord,
happen.
My lord, in this matter,
my lord, kindly fixed another 5 matters, my lord, which is
All right,
also.
give the numbers, give the
Yes.
numbers.
my lord, in this matter, the state is eager to file the report, my lord. It will be handed to my file today, my lord. The report has been asked for by the.
Is it in this matter, Milon based?
Milan Besra, yes.
We have to file the report, then we are filing the reports.
Report filed by the state is taken on record.
So give
The
a
matter
copy.
has been when the matter has been assigned before this bench by the Honorable Chief Justice. Stop. Report filed by such and such is taken on record. Release the matter tomorrow.
My lord,
For hearing, there are other matters fixed. Please check up.
my lord,
All right, you
give a copy.
Give a copy to your learned friend.
Yes, I'm giving.
Grateful, my
What
lord.
is the stand of the state?
My lord, that
Use the microphone because your learned friend is there.
my lord, we have filed the report, and the report says that the PMT and the physical efficiency is already completed on 2026, and the interview process is also completed in February 2026 in respect of the recruitment of this. Already
That-
testing are completed out of 19
No, that is
candidates.
all right. But the challenge was possibly regarding reservation or something.
Yes. My lord, there are twofold
Out of 19
challenge.
candidates, my lord. Out of 19 candidates, my lord, 4 candidates have appeared in the interview and submitted their ST certificate during interview. Out of cited 19 candidates, 1 candidate was absent in interview and 2 candidates were absent in the PMT and PET. And 12 candidates were found not fit in physical PMT and physical
My lord,
efficiency.
may I apprise this court, my lord, what is the issue? My lord, issue is
At
very.
the time of hearing.
At the time of hearing, my lord, yes.
My
Yes,
lord,
next.
arbitrary fixation of cut-off marks, one, and second thing is that the violation of reservation policy. These 2 points, my lord, involved in this matter, my lord. My lord will remember that is the point, my lord, and we are arguing in this matter, my lord. So, my lord, kindly keep this matter tomorrow. Grateful, my lord. Along with my lord.
এটা কি করে হয় হাজবেন্ড অফ দি পিটিশন
Tomorrow, my lord.
Yes.
Grateful, my lord. Grateful, my lord.
I oblige, my lord.
Item number 6, my lord, I am for the
For others, my lord, it's a past, not considered. I will not file any, but after this, I have told, already told, no matter in this file.
It is you who will advise. How will they know?
Today means, my lord, after 2017 sitting aside, DI is that to fix the pay scale about granting.
True. Now DI is not working. So what is to be done? All right. Now you file representation or request the DI to act. All matters we do so.
I will do that.
All right, Pradeep, disposed. কালকের অর্ডার গুলো same order.
I have got the petition of similar matter. Similar matter. Also. Seven matter. $14 matters. Five matters.
Yeah. কেউ আসবে না তো, উপরে তো মামলাগুলো দেখবে না না। ডাকুন। হুম।
My lord, I am for the petitioner, my lord. My lord, 16 July 2026, my lord, your lordship passed this order, my lord. I got the copy on 21st July 2026.
Who are you?
I am for the petitioner, my lord.
Petitioner.
345, my lord. Then and then I served the order, my lord, through mail and speed post, my lord. But speed post not delivered soon. but mail has been received. Kindly see the APT service. And 144. Oh, very good.
Take your seat. Take your seat.
Yes, great.
The order has not been complied.
No, nothing.
What was to be done? Kashinath Hembram
Yes, Pradhan.
and unauthorized construction.
Yes.
Yes, where is he, Pradhan?
He's outside. May I call may I call him? He's standing outside.
All right, tell me.
Yesterday at night, he received the contempt notice, ruled notice. My lord. It is admitted fact that no further step has been taken. As per his instruction, we have noticed both the parties for hearing, but the document we cannot collect because he has to come from Bardhaman in morning. But at the time of his coming, police obstructed his office to collect the papers.
Since when is he there in the post?
Well, at the time when WPA order has been passed, he is in post.
He was in the post?
I am tender apology on behalf of him.
Apology? 2024. We are in 26. 2 years. What was he doing?
My lord.
Huh? What was he doing?
Look, he did
not take any steps in the matter?
For the hearing, he called both the parties. As best
When?
When your lordship passed the order of WPA, my lord.
In 2024?
24, my lord. As per his instruction.
His instruction?
Yes.
And how did he call for hearing? Where is the notice of hearing?
Notice is the office of the Pradhan's office, but he could not collect the notice because police obstructed him to enter into the office before 10. He come here, so he could not collect that notice, my lord. As per his.
Were you given any notice?
No, mother, totally false statement, my lord.
Maybe.
Totally false statement. But your lordship earlier order issue rule. No response on the
Mr. Police.
Lordship, we came to know about this contempt rule yesterday only. I had a talk with the concerned Pradhan, upon whom the order was passed. We are an officer of the court and we need to comply with this order. We understand that. He has not done it. So the obvious question that from your lordship would be that why he has not done it for so long. I'm just humbly praying for 1 week's time. He will comply with your lordship's order. And as far as his conduct is concerned, we unconditionally apologize. If your lordship so desires, we can file an affidavit. But we want to comply with this order. There were circumstances due to which he couldn't. One step he took, he made a notice to both the parties.
When?
After the order was passed. Now, as for the instruction that I got, that both the parties didn't appear in that particular hearing.
The petitioner is here. He says that he did not receive any notice.
Now, my lord, my difficulty is that we need to produce that document before your lordship where the notice was sent. But unfortunately,
how do you know that the notice was sent? This is only an instruction because you've not seen.
No, I haven't seen.
Then, because the petitioner is saying that the notice was never served.
I most humbly pray before your lordship, let these proceedings be kept pending. I am giving this undertaking that he will comply with this order within 1 week.
Within 1 week?
My lord. And he will also...
Are you aware how much time was granted by the court for compliance? How much?
Lordship, I have gone through the previous orders of your lordship.
How much time? How much? Where is the brief?
Lordship, I have seen the soft copy of the...
All right, you've seen the soft copy. What was the time period granted for compliance of the court's order?
Lord, within 3 months of the passing of the order.
If 3 months time is granted, and now you say that you will do it within 1 week, you think that the court was having enough time? That is the reason the court granted 3 months time?
No.
Why? If the matter could have been done within 1 week, the court would have granted 1 week's time. The court would not have granted 3 months time.
The reason for keeping it within 1 week, I'm saying, is that we also need to produce before this court the document that we sent to this particular, both the parties for appearing before us. Now that one document we need to show. We could have produced it today only, but since he received the contempt notice yesterday through the police officers.
It's an absolute false statement that you are making in court. The contempt rule was served and he received it. He did not appear.
Yes, my lord. I inquired about that. The contempt rule was served.
Then you say that yesterday he received?
He received a contempt. The contempt notice was served in the year 2025 regarding
the contempt rule was served. Rule.
He is saying that he has come to know yesterday evening.
Let him stay in jail. Yes, do not defend.
Rashid, I am just humbly making a prayer, my lord. He intends to comply with this order, my lord.
I can understand what his intention is. 23rd of June, it was received. The contempt rule. Nobody appeared. Date of appearance was 2nd of July.
And there was a subsequent order of 16th July.
That's because despite receiving the rule, he did not appear. There was a direction upon the officer in charge of the Jamalpur police station to produce him.
I've seen that order, my lord. It is on 16th July.
He should have been put up in the lockup directly. He should not have been permitted to come here because he is in no mood of complying the court's order. Right?
I say on instruction that he will comply, my lord. I am since I have come, I've marked my presence over here. It is also my duty.
Where is your wakalatnama?
We need to file it. We will file it.
See, you have not even filed the wakalatnama. You are going on making submissions.
No.
That is the first step that you should take. File the wakalatnama in the department and then file. It's not you appear first and then file. That is not the system.
We are praying the need of your lordship. Well, since he came in the morning, we will execute the wakalatnama in the course of the day. This is an assurance from our part. We are an officer of the court and it is our duty to comply with each and every single order. Since I'm representing him, I'm making this submission. I'm first of all, I'm unconditionally apologizing on his behalf. And
what does the person do?
He does nothing. He's unemployed.
How does he make his livelihood?
He cultivates the other person's Rayati land.
When does he get time to serve as the Pradhan? What are the functions that he do as a Pradhan? He doesn't even know what he is supposed to do, isn't it?
What is falling from your lordship, I am also getting it, but since this was done on the
Pradeep. Note, same order to be passed. And the matter is made returnable on 20th of August. And the person will remain personally present in court.
Fine.
Leave to file wakalatnama.
Grateful.
Service is taken on record.
I once again unconditionally apologize if any submission of your lordship has. Grateful.
I appear for the petitioner, my lord. Today, my lord, my learned friend had supplied me an affidavit of compliance, my lord.
Who is he appearing for?
On the Pradhan.
Which Pradhan? All right, not complied.
No, my lord. He says, my lord, although, my lord, we on 1st of July, my lord, a date was fixed for personal appearance. 2nd, my lord, they issued a notice of inspection. Nobody came, my lord. 2nd July, yes, nobody came for inspection. In any way, my lord, it has been held that Nur Bakshir অবৈধ ঘর তৈরি করেছে।
How did he come to know?
That he
Was any
at
yes.
least.
No, are you aware of any notice
No,
for
no.
inspection?
Yes, date was fixed, notice was, but nobody came. Nobody came.
Yes.
Below, on 2nd July 2026, the date for appearance, personal appearance, my lord, on that day, my lord, the Pradhan, my lord, I am not at all, my lord, supporting the activities of the Pradhan. In spite of that, when he came to me, I advised her to observe the court's order to the point. My lord, on 1st July 2026, my lord, on 26th June, 29th June 2026, my lord, a notice was issued that pursuant to this honorable court's order, a meeting would be held, my lord, at Panchayat office. Time was given. My lord, the writ petitioner, he refused to accept the said notice. My lord, but on the 1st July 2026, he personally appeared in the meeting, put his signature on the, my lord, Panchayat office.
What is the requirement of the meeting?
My lord, because your lordship asked for compliance of the order,
What was the order to be complied?
my lord, whether the construction was unauthorized or not.
How will you understand that?
My lord, the inspection was done.
When?
My lord, on my lord, same day, on 1st July,
Was the inspection done upon notice?
my lord, notice was given.
For inspection?
My lord, on the meeting, all the parties that
Was the notice of spot inspection given?
spot inspection regarding this, after their discussion, they told that
After discussion, spot inspection? What does it mean? Predetermined order you will pass so that it is challenged and set aside? Is this the way?
no, my lord, my lord, a separate notice is to be issued, my lord. This is, my lord, I understand, my lord.
Then where is that?
But my lord, the inquiry, my lord,
Same order.
my lord, the inquiry, this writ petitioner was present, my lord.
Affidavit of compliance, the alleged affidavit of compliance, affidavit of compliance alleging compliance of the order passed by court is taken on record. Copy of the same is handed over, released on the 20th. The SEO will take up the matter, see what's there. Next, and 20th, the contemner should personally come.
28th, my lord.
Great.
No more personal appearance. One 46.
None. So this is that recalling application. My lord, initially, my lord had passed an order by which, my lord, your lordship had directed the defreezing of the account, my lord, which was frozen. The Axis Bank was directed, my lord, to defreeze it. My lord, this was done on a complaint which was made by me. When your lordship had passed the order, my lord, your lordship had recorded that it was on a complaint made by me, but I was not made a party in the proceedings at all. So I filed a
Which proceeding?
before your lordship.
All right.
So I was not made a party at all, and I was not heard. That's my only complaint for the moment. My lord, after your lordship passed an order, my lord, this was carried in appeal. In appeal, my lord, it was a lot of things were gone into. The entire matter was gone into. My locus standi was gone into. The learned judge, the honorable division bench held that I had no locus standi, and everything was threadbare gone into. That judgment, my lord, was again, my lord, carried to the Supreme Court. The Supreme Court deleted all those observations which were made. Any observation which were made, my lord, they were asked, my lord, not even to look at it. So your lordship was directed, was requested, my lord, to hear out that application for recalling again.
So my first and basically the only point would be, my lord, seize your lordship's first line of my lord's order.
Date.
9th of April 2025. Probably at page 43, my lord, of the application.
Yes.
See the first paragraph of my lord's order, my lord. The petitioners are aggrieved by the act of on the part of the Axis Bank in freezing their bank account and demat account, relying on a complaint lodged by the erstwhile directors. Admittedly, my lord, we were not made parties.
You are Insilco agents.
Yes, I am. I mean, Insilco. We were erstwhile directors. Looks to my lord's line, my lord, it's there. By the erstwhile directors of Insilco Agents Limited in May 2021.
Yes.
Their application. I am them. Well, this is those many Birla Lodha matters which happen. The erstwhile directors are removed, the new ones come in. Is one of those.
Insilco agents.
Milord, in my respectful submission, today, Milord forgets about who I am. I am the complainant.
The bank also took note of the recording in the website of the registrar of company. What about the management dispute between the directors?
Milord, it's still on before the NCL.
Still on.
Still on.
Registrar of companies thereafter demarked the recording of management dispute.
They are saying no. I don't know. Milord, that's on instruction. If Mr. Chaudhary says no, Milord, my instructions are it's still on.
Milord, I keep quiet when the other side is arguing.
No, you don't keep quiet at all.
It is up to you to be factually correct.
It is not at all for me. It's on my instructions.
The petitioners approached the bank with the request to defreeze the subject accounts.
Milord, what played with your lordship was that there was a remark which was made that there is a management dispute.
Okay. ठीक है sir.
My lord's reasoning is at, my lord, paragraph 8 and then 10. After this order, my lord, your lordship passed this order. My lord had recalled this order. If your lordship, my lord, remembers. Your order page ka to? Your order page. Recalled. Against which the appeal was put.
By this order, the court directed to defreeze the bank account
Yes.
and the demat account subject to depositing an indemnity bond as per the norms.
Then your lordship recalled the order on our application.
The formalities
That order I
for
wanted to show your lordship.
submitting the indemnity bond. Access.
If that to be right.
That's why I'm telling them keep quiet.
The order stood recalled, video order dated 19th of February or when?
Yes. Yes.
Acha.
I wanted to show your lordship that order. It should be in your lordship's
Recording of
brief,
the order is separate.
That's been separately given, if I'm not mistaken.
They
The
give me the
19th June 25, if I'm not mistaken.
19th of June.
That's correct.
The application for recalling has been filed by the applicants not parties to the writ petition from which the contempt has arisen. Then a contempt came up.
Yes.
The grounds for recalling necessary parties were not implemented.
Kindly see paragraph 3.
Matter
then
is
4.
required to be heard. Application for clarification is also filed. All right. Well, that means 9th April's order could not be acted upon. Whether
not
it is
be acted.
recalled, not recalled, it
My
could
lord.
not be acted
Acted.
upon
Due of
because
19th June.
of
19th June.
no. Even prior to 19th June.
Because he stopped.
Yes, his application, right. Yes. Right.
So I left it to the court. This is my format. There was no order.
Could be acted upon.
So indemnity has to be as per my form, as per the section. That's also not correct. But there was no order. Your lordship passed this order, my lord. Then we filed an appeal. Appeal court, my lord, considered.
I come to that then. Then I come to that.
I know orders
On
of
this order, my lord, there was an appeal which was preferred by Mr. Chaudhary's client before the Honorable Division Bench. But the Honorable Division Bench's order was this.
I have a copy.
Lordship has a copy. But there were plenty of observations made all over.
It is 5th of January 26.
My lord. My lord.
Right?
My lord.
Yes.
5th of January 26.
Yes.
There, my lord, your lordship will find a lot of observations were made. Then look at the Supreme Court judgment on that. That also is probably there before your lordship.
Is it annexed in the application?
No, my lord, it was much later. So
Supplementary affidavit, is it annexed?
No, I can give your lordship, my lord, a copy.
Wait 1 minute. Don't pile up papers.
May I do this? May I, my lord, make a compilation?
No. It's just one order. I've got copies.
No, don't.
My demat is stopped for 6 months.
The order passed by the Supreme
For
Court
years.
has been placed.
No, 6 months after.
Matter is
अच्छा ओके बोलते थे
recalled.
ठीक है
अच्छा.
Why
Opposes the
why do you want to get into that?
All right.
Where is the Supreme Court order?
24th of March 2026, Supreme Court's order is there. Somebody recusing, one of the honorable judges.
Yes, thereafter that was there, my lord. That's why we had sought for time on that occasion. Then, my lord, finally it was heard out. My lord, that's the judgment of 11th of May 2026, if I'm not mistaken.
Yes, then. So it has to be heard afresh.
Without even taking into consideration any of the observations made, my lord, by the division. Kindly have a look at
what we showed.
Have a look at paragraph 4. We do not find any error, not to speak of any error of law in the impugned order passed by the High Court. The High Court has made itself clear that it has not gone into the merits, and the learned single judge shall decide all the issues without being influenced in any manner by any of the observations, and also without prejudice to the rights and contentions of any of the parties. We also reiterate the same. It is needless to clarify that the single judge shall decide the applications without being influenced in any manner by any of the observations made in 30 to 48, specifically, respectively, of the impugned order. Now, my lord, I have a very simple point before your lordship. When I have made a complaint, I had a right of audience before your lordship.
And the complaint was before?
The ombudsman. Before the ombudsman. And on that, my lord, the account was frozen. When they've challenged that act, I had a right of audience before your lordship. I'm making it way simpler, not going on into anything. And that is what my lord realized, my lord, or rather, my lord recognized and passed that order from which, my lord, the appeal emanates. So today, my lord, my only submission before your lordship is, without going into the merits at all, is to kindly recall that order and hear the writ afresh, adding me as a respondent. I am basically, my lord, on Order 9, Rule 30. On the simple premise, nothing
who
beyond.
is the writ petitioner?
My learned friend's client.
You are the writ petitioner. What was your allegation?
Lord, my demat account is not being permitted to be
It has been
operated by the
frozen.
bank. It's
It has been
frozen.
frozen.
It's been frozen. And my lord, I move a writ petition, your lordship, because your lordship, my lord, recognize, my lord, the law, my lord, laid down in several judgments that without an order of court, you cannot freeze a bank account. And the bank account was opened. Now, my lord, he comes up suddenly from somewhere and says, as he says himself, I'm a past director, and he files an application for impleadment and obtains a stay of the order. Against that, my lord, we file an appeal. Appeal court vacates
Is the
that.
bank account yours?
Yes, the companies. Now,
Company.
question is, who is
The
he?
company account.
Company. He's a past director. He has no locus. He said two things before your lordship. Number one, that there are disputes marked. What he has not told your lordship is those dispute markings have been unmarked by the ROC. Second fact, somebody else, my lord, at his behest, goes and files a petition before the NCLT under section 241, 242. No orders passed there. Appeal also, my lord, no orders passed till today. Dismissed. NCLT dismissed. In appeal, no orders passed. So at the present, my lord, he has no locus to complain. This is a company who's represented by, my lord, its directors as per the MCA records. And he wants that this company wants to utilize its demat account. There is no order from any court. And this is, my lord, the latest master. Mr. Banerjee, please.
I'll hear you. I'll hear you.
Yes, separate application.
I'll hear you.
Which was suppressed.
No, very.
Paid on your lordship.
I will hear you.
Please.
My lord, I have handed up MCA records in respect of the.
As of 1st July.
As of 1st July, my lord, we are the directors.
If he had so much of, my lord, positivity, then
I
should not
do,
have
my lord,
taken an order behind my back.
There's no.
He was so. I'm the complainant. Who am I? And in unison, you all can't.
রেগে যাবে, my lord, the
Where is
reason.
the names of the directors?
Yes. Overleaf, my lord.
Is
Let's
it
take,
all
my lord, the first one, my lord, in Silco. My lord, please see, my lord, who the directors are. Rakesh Kumar Puri, Ravindra Pratap Singh, Meenakshi, Vinod Keshwari, Bachraj Nahar, and Siddhiram Raman. There is no Daga, no Damani, no Sureka, no Vinod Sharma. Same, my lord, names your lordship will find in the other two companies. Now, my lord, kindly take the application which has been filed. Please see, my lord, who's affirmed it. Which is, my lord, my learned friend's application. Please see, my lord, paragraph 1. This is, my lord, IA number 2. Can number 2. Applicant numbers 1 and 2 are existing directors of the petitioner. Completely incorrect statement.
Yeah. Can do.
Can 2. ওখানে নেই নামটা।
Which page number is it there? Can two?
Can 2, my lord, paragraph 1.
Oh, paragraph 1. তাহলে প্রথমেরটা।
Lord, please see, my lord, who's filing the application. Krishna Damani.
Yes.
Sushil Daga. Vinod Sharma. My lord, and they say, my lord, in paragraph 1 that applicant numbers 1 and 2 are existing directors. Totally, my lord, wrong. Today, my lord, he says, not existing director. I don't, my lord, want your lordship to believe either me or him. Please believe MCA records. Companies Act says, until to the contrary is proved, MCA records, my lord, are binding.
Completely irrelevant.
Now, my lord, so few persons come forward and say that we are directors. MCA records do not show they are directors. And the same persons, my lord, also go to, my lord, have a management dispute marked. That management dispute has been unmarked, I want your lordship, my lord, to please see that document. Please see page 200 of the writ petition.
200 of the writ petition.
Yes, my lord.
আমার একটা কপি দে
200 of the writ petition.
দে আমার কপিটা
তোমরা লাগিয়েছো অ্যানেক্স করেছো
আমি করতে পারি আমি তো নেই আমার
সি দ্য ডেট ফার্স্ট
My lord, kindly see, my lord. 15 July 2021. This is, my lord, by the minister.
Just wait. 200.
They never moved there since 2020 because we pointed out that there was a scam by the ROC.
Yes, 200.
Yes, my lord, this is an ROC document, my lord, Office of the Registrar of Companies.
200 is a letter from Dinesh Kapoor, company
That,
secretary.
My lord, 200 of writ petition.
200 of the.
Oh, my lord, this is,
Three writ petitions.
my lord, there are 3 writ petitions, my lord. Your lordship has, my lord, the number, I'll just give
The 6112.
6112. My lord, kindly give me a moment, my lord, I'll give the
Do you
correct
believe?
page number.
Okay.
This is, my lord, আরে নাম্বারটা বলো না। My lord, in August agents writ petition, my lord, it's to page 200. I will just give, my lord. Sanket, please physical briefs বার করো।
Which one is there in front of you?
My lord, August agents, my lord. Page
August-
200 is the letter.
1 minute. Which,
My lord, I will
which
assist
item
your
will it
lordship
be?
better.
Which item will it be?
What is the number? 6088, my lord, is
August agents.
my lord, please see
6088.
6088, my lord.
দেখুন তো।
6088 page 200. Now don't deviate and go to other credits. Huh? Take
Page
out.
200 of the writ petition. একদম নিচুতে হবে।
there's one problem. He is talking on merits. Milord, is he disputing that on my complaint, Milord, this order was passed? This
No,
is what
let's-
the point is at the present
Milord,
moment.
they will let
He
me, Milord.
cannot talk on merits, Milord,
Milord,
before your
last
lordship if
6
I'm not
months-
there.
পরে 200.
And there are a couple of other issues also. Lord, with regard to the application, before we get into this, Lord, could just bear with us for 2 minutes. Lord. Because the 9th
Because he's
April-
trying to drag it as if, Milord, the writ petition is being heard.
That's right. Well, the 9th April order was recalled by your lordship on 2 counts. I'll just address your lordship on that, because there will be an issue of law also. So before you
But,
get into who am I and I actually should
friends,
not
my
be
lord.
heard.
Just wait, I'll hear you.
Yes,
Yes.
Milord. Please, Milord, see page 200. Please note, this is not ROC. Subject is demarking the company August Agents Limited as having management dispute. Dear Sir, Madam, please note that the company August Agents Limited, having since such and such, has been demarked as having management dispute with the following reasons. And the date, my lord, is 15 July 2021. Top left hand, my lord. Now, my lord, please see the second paragraph. Letter dated such and such, email dated such and such with respect to demarking in respect of 3 companies, August agents, Insilco agents, and Lanacera agents, and also such and such directing compliance for unmarking status of company from management dispute and changing status of approved e-forms for pending due to management dispute. It is worth noting that action with regard to marking of management dispute with ROC was in compliance of the direction of the APL committee appointed by the High Court. This has been, my lord, informed. Now, this, my lord, is challenged in separate writ petitions before this honorable court, never moved.
Replied and
Mm,
it was
Lord,
argued.
so, my lord, there is no order staying this or challenging, my lord. I'm sorry, there's no order setting this aside or staying this. And I've shown your lordship, my lord, this was in compliance with directions of APL committee. if there was a dispute with regard to, my lord, functioning of APL committee, that has also been resolved by the division bench and clarified. So this is number one. There are no management disputes. Number two, please, my lord, take the judgment of the NCLT. This is, my lord, in Silco, the public document.
Why do you want to rely on this?
To show, my lord, I want to show your lordship the cause title. Mr. Damani, Mr. Kapoor, in Silco, they're all, my lord, here. This is regarding, my lord, the functioning of these companies. There is, my lord, this is dismissed. They go to NCLT, don't get any order. So they cannot contain that Mr. Damani, Mr. Daga, etc. are directors. They have to accept the fact that the persons reflected in that document which I showed your lordship are directors. So the persons who are today representing the company before your lordship, they are the persons on MCA records. Attempt to move them, my lord, have all failed up to NCLAT till today. Appeal is, my lord, in the list. It's pending. No order there. And 15.23 of this judgment at page 112. You know, there's one paragraph I'll read out.
Internal page 11.
Internal page 112.
On record, there was absolutely no action of consequence.
15.24. On record, there was absolutely no action of any consequence, save and except that the ROC seems to have been cajoled into marking the subject companies as being under management disputes. This was the chickenry on the part of the subject company, since on 22nd April, there was no management dispute. Boards of the subject companies were united in their decision. The VTL should not be allowed. That's on a different matter. So management dispute was also castigated. So, my lord, management dispute gone, writ petition, no order. Daga Damani, nobody in question. Attempts, my lord, to show, my lord, confusion in the management of the company fails. Operation mismanagement action fails. So, my lord, they are nobody. They are, my lord, Daga Damani. Now, what is the status? Status is, bank, my lord, freezes my demat account for 5 years. We come to court, my lord, with an argument. Without an order of court, bank cannot freeze my, my lord, account. Bank, my lord, says, my lord, plenty about indemnity, etc. But now I am on my learned friends. Your lordship, my lord, recognizing the law, passes an order. Now what happened? That order was not being complied by the bank. I filed a contempt. That was a separate matter. But in the meantime, they, my lord, appear and they, my lord, file an application for intervention, on which, my lord, your lordship was pleased to, my lord, direct that no effect to be given. Today, my lord, I am firstly on the intervention. The gentlemen who have come before your lordship, A, are not directors of the company. They are past directors. They have no locus in respect of the company or its bank account. Management disputes, which was done indirectly at their BS, my lord, is gone. So, my lord, they are nobody, they cannot intermeddle.
All right. Followed.
This is, my lord, management dispute order.
The writ that they challenge it.
Since
See,
January
the court is of the
2022,
view.
the matter has never been mentioned by them.
They will not challenge. Heard Mr. Satinchand, learned senior advocate, court adjourns the matter. This court is of the view that the petitioners in the 3 writ petitions must first demonstrate the source of authority or the power of Ministry of Corporate Affairs to issue circular provisions of law such as to declare company which appears to be an adjudicatory power must be clarified. These will be treated as preliminary issues apart from the question of territorial jurisdiction. And that's the end of their writ petition. Never, my lord, prosecuted,
After
no
January
order there.
2022,
After January 22. They are nobody. I want to operate my bank account. They are nobody to, my lord, interfere.
All right.
Milord, I'll deal with the bank later. First, Milord, intervention.
Say, Mr. Chaudhary, I
Milord,
don't make a
Milord, the bank has nothing to do with intervention. He is acting at their behest.
You'll speak for everyone. That's the problem.
No, the
I speak
problem
for
is,
everyone.
the problem is,
Submission, I have a right.
Milord,
There is an application for intervention. What is your submission?
The intervention, Milord.
You do not have anything to say.
Milord, the appeal court says that after the outcome of the intervention,
Then you come in.
I come in.
So just wait.
That's all.
One of the interventionists have made submission. There is another one also. I'll hear.
I'll try to make a submission.
All right.
I'll just
Yes.
address your lordship on two things.
What is your CAN number?
146 is mine. So my two things, but
Nine-
I'll just
1 minute.
yes.
এটা যেখানে
I'll address your lordship on two issues. Mr. Chaudhary's addressed your lordship on who am I and why I have on the merits of it and why. Two issues that had weighed. When the order that was passed on 9th of April was passed.
tell me, why do you want to intervene
I'll-
in somebody else's writ petition?
So that's the first thing. Well, your lordship will just have a look at 9th April 20. I'll give a brief overview, on what ground we want to be coming in. One is, my lord, writ petitioners come in and seek an order against Axis Bank. Axis Bank to defreeze an account, stating that this is now, it's defrozen and therefore I should be allowed to come in. They suppress very, very conveniently a host of facts. One is that the NCLAT, well, there's a reason why your lordship passed that order on 19th of June, recalling this order and impleading me. Three things had weighed on this honorable court. One is suppression of the fact that the NCLAT was pending, where this entire issue, apparently, according to them, was already decided. It could not have been. Well, these are two separate, independent causes of action. If that NCLT matter was sufficient to give them this relief, then a separate writ petition would not have been filed. That naturally does not cover this. The entire writ was premised on the basis that this was made at my complaint. And very conveniently, the complainant is not impleaded. Two facts are suppressed, which now finds voice in court and very vociferously is the NCLAT. One other fact that is very conveniently suppressed is that the matter of removal of me, removal of this marking of a management dispute was pending before a writ petition, by a writ petition. Had that been informed to the court, had that been informed when the 9th April 25 order was obtained, and why I say obtained, not because I'm alleging blatant suppression of fact. This is not pleaded in the writ anywhere. This they don't come and indicate to the court. The other also, that this order your lordship will find is of April 2025. Even after that, the bank writes to me as the authorized signatory. Taking your lordship's order, that later gets changed. Well, it will come down to two issues. One is, if your lordship looks at the 9th April order, whether a complainant is a necessary party, only after I come in, does my locus become an issue? Well, this is absolutely on the merit of it, saying once I have been removed. Another very important fact that is suppressed is this management dispute marking they take before the RBI Ombudsman. These facts your lordship will not find from the writ petition, which is why my presence is necessary. There is a discernible distinction between what is happening or has happened in NCLT. Anyways, the action is pending before NCLAT. And what is being sought to be done through this writ petition today. What they suppress also is taking this demarking or marking of frozen account. They had gone before the RBI Ombudsman. That was rejected on the ground that this will have to be taken up elsewhere. So that becomes a parent order. That also they don't assail here. Here, simpliciter, an order is now obtained against a private bank where the law is now recently absolutely settled by the Supreme Court that against a commercial bank does not discharge any public function and therefore writ doesn't lie. This also I had indicated and the 19 June order was passed. Opening line of your Lordship's order of 9th of April, if I may just show once more, my lord, of which we are seeking recalling. 43. My lord, I have been removed as a director. My removal is one aspect, which is now pending before the NCLAT. What was marked as a management dispute, that declassification or unmarking is also pending. Both these facts are suppressed from the court when the 9th April. One other startling fact, not, and I'll say this because when we were moving this, your Lordship was sitting in courtroom number 18. I was moving the recalling. A blanket statement was made in court that we don't want to file an affidavit. Your Lordship was invited to pass an order straight away on the recalling. First ground in appeal is affidavits were not directed to be filed and could not have been granted. I'll show the ground. So everywhere, you know, these suppressions are being made as if I come in, it is going to become a problem legally. The only issue now, when I come into the proceeding, an addition is made. Your Lordship will then probably have to do this arduous task of whether that what is pending before NCLT has any bearing on this. Whether if I am the authorized signatory, whether if I am the authorized signatory, bank is writing to me later, that can be changed. Whether bank is at fault here. Because the writ is not, it's against a private bank, against Axis Bank here. Whether bank is at fault here is what is really their cause of action. The complainant, admittedly at whose behest this has been done, they use that, but they don't make me a party. If I may ask that question, why? And why are these facts suppressed from court? The petitioner will not pick and choose which fact, if indicated to the court, would become relevant. These two facts are not. Today, a lot of voice is lent that, look, please have a look at this order is pending. This was not shown when the 9th April order was obtained. That at my behest, the writ was pending in court and you came and took an order behind my back. You say I'm the complainant. You don't implead me. Who am I? And what is my locus is possibly on merits, which is why your Lordship has passed that order, recalling this order of 9th of April. Because I had shown the first paragraph of your Lordship's order of 9. I am not shying away from the challenge that they have made to my locus. What will I say if I come in? For that, I'll have to come in. I am only saying that I should be heard. When the 9th April order is passed, two facts, factually, I'll just indicate and I'll show two judgments. Please come back to the order of 9th of April, which is page 43. Page numbers will match, right? আমি কোনটা থেকে দেখাচ্ছি বুঝতে পারছি এটা আমার তো এইভাবে আসছে এই দেখো না অগাস্ট ইনসিল করে এসেছে page 43 I'm just relying on the 9th April order my lord.
It's can 1.
Which one? Whichever one your lordship is looking at, I'll try and give the correct page number of that.
I'll give you the right page.
Eta konta? Page 43. It's the same for.
Yes, 9th April.
Yes, 9th April. The petitioners are aggrieved by the act on the part of Axis Bank in freezing their bank account and demat account. Please mark these 4 words, my lord. Relying on a complaint lodged by the erstwhile directors of August Agents Limited in May 2021. Issue number 1. Whether a complainant is a necessary party or not. Because this is admitted today that it is on my complaint that this order was passed. So today, let us leave aside such a fancy litigation. Let us come back to any of these municipal corporation matters where a person responsible has come to court against the KMC. The complainant who has made the complaint of unauthorized construction is not on board. If I just digress and look at a slightly wider perspective legally, Second, it's against Axis Bank. It's a scheduled commercial bank against whom a writ is not maintainable. Paragraph 2, please see, Register of Companies thereafter demarked the recording. It appears erstwhile directors approached NCLAT by filing at Ahmedabad, intervening application filed by Axis Bank in said company. Petition also stood dismissed. NCLAT pending, not informed. Nowhere. Notice that the appeal has been preferred. I'm sorry, appellate tribunal, no stay has been passed after 2 years of filing the appeal. Prayer has been made by the petitioner seeking a direction of Axis Bank to defreeze the bank account. Learned counsel representing Axis Bank raised a preliminary issue with regard to maintainability. Representing performers as submit 100% shareholder. Record that there's no order by any judicial forum directly permitting the bank to pre-freeze their bank account and demat account. And your lordship has passed this order. Now please have a look at the next order, my lord, by which your lordship recall this, which is of 19th of June. What did the court do and what am I seeking today? Please have a look at the 19 June order, my lord. I believe it will be separately. If your lordship desires, my lord, I can just hand it. I can hand it over.
Why is it not here?
It
must be there.
It will not be a part of my recalling application because on this it was passed. If your lordship could just look at it separately, my lord.
Yes.
An application for recalling, thank you. An application for recalling has been filed by the applicants, not parties to the writ petition from which the contempt has arisen. The grounds for recalling the order are that the necessary parties were not implemented as respondents in the writ and that the order has been passed behind their back. The said parties are proper and necessary parties and they ought to have been heard for effective adjudication of the subject list. There has been gross suppression of material facts. After hearing the submission made on behalf of all the parties, it appears that the matter is required to be heard. An application for clarification Axis Bank has been filed. Contempt shall be kept in abeyance. The order passed by the court shall not be acted upon by any of the parties for the time being. Leave for filing the application seeking intervention stands allowed. Applicant shall formally be added in the writ petition and copy and thereafter it is to be heard. So we come down to one issue. 3, if I slightly widen it, 1 is that whether a complainant is a necessary party or not. Just that once I am added, why am I required to be or what do I have to say on merits is another aspect of it. And to just highlight that, well, if I had come in, what could I have shown? Very well. Mr. Chatterjee rightly advises me not to get into it because it's not required right now. My only other aspect, my lord, at this stage, even before your lordship is considering, my lord, the point of maintainability is something that we had argued and we had cited a decision also. If your lordship desires, we'll just cite that formally for the sake of completeness.
Give.
Yes, my lord. Because the writ and the order is against Axis Bank.
They are not yet parties.
So exactly.
Writ is disposed.
I agree with
disposed of writ.
I agree with
you. Party application, and he says that.
Well, this is the catch.
Without me becoming
so it keeps
party,
coming back to
petition.
It keeps coming back to that.
Show me the judgment that you are relying
Yes,
upon. Axis Bank.
Yes, ma'am.
And this matter is considered in paragraph 10 of the judgment. Submission of the bank considered an order passed in our favor. Addition of party applicant without being added will now supplement rejected
Very well, very well. So, so I will not.
Give me a hard copy. Do you have one?
Yes, my lord, we have one. Just give me a minute, my lord. Yes, your lordship will just have a look at this. This is 2025 SCC Online SC 177. Kindly have a look at paragraph 9. Paragraph 7. No. 7 also, if your lordship could just have a look at. applying the above test. এটাও কি Axis Bank এর against it? Applying the, I'm sorry, paragraph 7.
Yes, yes, read.
Applying the above test, the respondent herein cannot be called a public body. It has no duty towards the public.
You can continue. I
Very
can
well.
hear.
Its duty is towards its account holders, which may include the borrowers having availed of the loan facility. It has no power to take any action or pass any order affecting the rights of the members of the public. The binding nature of its orders and actions is confined to account holders and borrowers and its employees. Its functions are also not akin to governmental functions. Not paragraph 9, I'll just show one particular paragraph, not paragraph 4, subparagraph 4 of paragraph 9. A private company, in this case Axis Bank, carrying on banking business as a scheduled bank cannot be termed as a company carrying on any public function or public duty. Normally, mandamus is issued to a public body or authority to compel it perform, then your lordship will find that it was held, this is not maintainable. So coming to court against Axis Bank, and he's right, Mr. Chaudhary, for once I'll agree with him, that I need to step into the box to fight this fight. You can't say I'm a complainant at my behest. This is done, but I will not be allowed into the ring. Because if I come into the ring, three things will come up. One is you've suppressed facts. And we're carrying judgments to show suppression. Your lordship has held suppression is patent fraud on court. What does he suppress? The pending writ. What fact is going to weigh with the court, what is not for him to decide. Full disclosure is what we've learned. And you say I'm the complainant, opening paragraph is that. And in how many matters, we got tired trying to look at these decisions where your lordships have directed implead them. Implead the complainant. Private respondent is not there. Only come against the corporation or against the authority. Then 8, no? Yeah. Paragraph 12 of that report, your lordship has seen 10 onwards, and it was dismissed on the ground of maintainability, it gets upheld. So writ against Axis Bank is actually not maintainable. But I am not being allowed to address your lordship on this. The other aspect is of suppression. Suppression, that is removal of or declassification of this as a management dispute, is under challenge before this court. The same is pending. Maybe if this was informed to the court, it would not have weighed. But maybe it would have. When I am not given a voice, he comes up. It was his first responsibility to come and say what was important. And then don't come and say it. But again, one decision on this, that suppression of a fact is a fraud on court. So this entire aspect of after disposal, application doesn't lie, fraud unravels everything. It is with this, and with some responsibility I say this, because I was moving it. It is with this that had weighed on the court by which the 19 June order was passed. It was the fraud that we had addressed. And fraud on court unravels everything. So these procedural so-called infirmities, just for the sake of completeness, I'll cite this. This is on 2010-8 SCC 383. Paragraph 28 onward. Copy. Up to listen to March minutes. I can't listen to any more. Then you should hear.
Paragraph
28 onwards, Your Lordship, will just have a look at one.
yes.
Just give 28 and 29 a cursory glance, my lord. It vitiates the proceedings also.
All right.
(38), Your Lordship will see suppression has been considered as a fraud. And 39, my lord, the respondents have never been able to show as under what circumstances their interest in the suit land, because before the special court they failed to show any document, and then they tried to rely on something else, and then they suppressed it. So that suppression, the other suppression, my lord, these are facts that when I'm addressing Your Lordship, they may not be relevant. May not be relevant so far as merits are concerned. But one thing that is there, my lord, even this removal, they challenge before the banking ombudsman. And there's a rejection of that challenge. That challenge is not on that.
Yes.
That removal or the order of the banking ombudsman is not under challenge here. They go before the banking ombudsman, get that order that this is not going to be and not going to interfere, keep that, don't inform Your Lordship, file a separate writ against a scheduled commercial private bank. This also they don't come and inform that we had gone before the ombudsman. And I'll show that order. It's a part of my. Please have a look at this. Your Lordship will find this at page 428 of the application.
428.
Look, these are facts that have to come on board.
428 page. 428. 500 চলে গেছেন 500 চলে গেছেন 428 ওই যে মাঝখানে $428.
428, my lord.
Is it a part of any order?
No, my lord.
Which is the page number? There are two page numbers.
Uh,
Are there two page numbers? One in the middle.
340. One with 428 at the top, Your Lordship will point.
At
One
the
that is
top.
underlined.
Underlined.
Yes, that 428 of that.
428. Judgment is in 428.
This is Insilco's agent's letter to the chief general manager.
This is a closure intimation for complaint against Axis Bank.
Yes. This is me going, not him going.
That's right. Which is why I'm saying you
Don't say
suppressed
you said
it.
you went before.
No,
You're
he
giving
went
incorrect.
and he suppressed this.
You did not go.
Oh, he went. Mr. Chaudhary.
You said we went.
এটা থেকে হ্যাঁ 424 আপনি হলো 420 বলিস ওটা suppressed 424 Your Lordship will see.
Yes.
This is of 25th of September 2023. The writ petitioners first went So I obviate this confusion about we and I. Writ petitioners went to the banking ombudsman against Axis Bank. That complaint was rejected or it was closed. That closure was never assailed. They don't come before the court under the scheme. They directly come and file a writ suppressing this. Hmm? And please have a look at, my lord, what is there, paragraph 2, as per bank submission. At page 424 of.
All right. Since an issue has been raised with regard to the maintainability of the writ petition,
Yes.
what will be your
There's one more.
reply?
My lord, immediate.
One thing may I add.
Yeah, may I give my
First
reply?
submission was,
I'll hear you.
my first submission was, is it true that it was on my application, my lord, the account was frozen or not? Mr. Chaudhary has not even said a word that it wasn't on my application. Many submissions have been made about
I want to give
No,
reply.
yes.
If you give, if
Say
you
the
let me, I will
complainant
give
was not
reply.
heard. Complainant was not heard. This is your submission.
Yes.
All right.
Let me quickly deal
I've
with
got
the.
it.
Let me quickly deal with the points.
So
First is
first, with regard to the maintainability issue, one, and second, there are very many disputed questions of facts which the writ court cannot decide.
Which is why I'm not being allowed to come in. It is just with that, my lord, that I have been kept out of the
The
ring.
moment the question comes, they all start in unison. They will talk.
Yes.
Lord, may I respond? First issue, banking ombudsman is part of.
Not the banking ombudsman.
Very
You
well.
say
Complaint.
how the writ will be maintainable. The court permitted the writ and passed order
Yes.
only with the view that your banking transaction was involved. Right. Now, this issue of maintainability was raised by the bank. It is not that it was not
Considered
raised.
by your lordship, held in my favor.
There is no such
Paragraph 10.
paragraph 10. There is a submission, but was it dealt
Your
with?
lordship is now considering an addition of party application. May I address?
No. I'm not considering. I'm considering whether the writ will be maintainable or not. Then I'll see whether to add him or not. You say whether the writ will be maintainable or not.
I've challenged the addition of party, my lord. Your lordship is not considering. I will not.
I have heard. I have not passed order whether I will
No, but I want
allow
to respond to that.
No, just
I'll come back.
on the maintainability.
first whether the writ will be maintainable or not. If the writ becomes
But your
maintainable,
lordship has
then
held it's maintainable. And your lordship has disposed of the writ.
the matter has come back all over again.
Yes. But what has it come back for? It has come back for addition of party and contempt.
Jurisdiction, your lordship is precluded from looking at.
This
Is
the
this
court
what the
will
petitioner is
consider.
submitting?
But Lord, please have a look at the order
Court
of
is
the.
precluded
No,
from
no,
looking at his
no,
jurisdiction.
1 minute.
Please do not
What is
interfere.
going on?
What, Mr. Chaudhary?
Lord, please.
Not in between y'all.
No, never.
Yes.
Lord, please see the division bench order.
Cannot see. Cannot see.
Show me the Supreme Court's order.
No, yes, Supreme Court's order and division bench order. Hey, respond to it. I get distracted. I won't be able to do it. Lord, please see.
And you feel distracted and you think that
No,
the
no,
court
I
will not
get
be
distracted by my juniors.
And I am distracted by
I
everybody.
keep telling them, don't say this, my lord will get angry.
No question of being angry.
I've been telling them.
No, that is
When he's saying something.
your way of placing it. But it's not that the
No,
court
I
is
know,
getting
my lord,
angry.
your lordship
Correct.
is getting disturbed. I can understand that.
Yes, it
They are
becomes difficult.
one statement from us, they are responding. One statement from them, we are responding. Your lordship is trying to concentrate.
But the court knows how to navigate.
Yes, I know that.
So just show me the Supreme Court.
Yes.
Order. What is there? Right
Paragraph 3. We do not find any error. Do not find any error, not to speak of any error of law in the impugned order passed by the High Court. Now I want your lordship to see the High Court order, and then I'll read the rest of it.
No, but then even after that, the Supreme Court has mentioned that
Yes,
the
so
single bench
that's
will decide without looking into the order or the observations of the division bench, isn't it?
Milord, yeah, absolutely, Milord, but I want to put it in perspective. I want to show first that what was the division bench order, what were the directions, and then, Milord, what is
What is the use? All those came up
Milord,
for
please see
consideration
the
before
Supreme Court
the.
order. Please see the Supreme Court
Yes,
order.
read out. I do not
The
find the
High Court,
copy right now. Just read out
yes,
what is
the
there.
High Court has made itself clear
Hmm.
that it has not gone into the merits,
Hmm.
and the learned single judge shall decide all the issues without being influenced in any manner by any of the observations, and also without prejudice to the rights and contentions of any of the parties. We also reiterate the same. So I wanted to show, Milord, that High Court judgment paragraph. It is needless to clarify that the learned single judge shall decide the applications without being influenced in any manner by any of the observations made in paragraphs 30 to 48, respectively, of the impugned order. Learned single judge shall take up all applications pending before him for hearing and see to it that they are disposed of. Now, what are the applications? There are two applications. One, clarification, intervention, contempt. Now, Milord, please see the applications. First, Milord, so it's the applications which are being considered today. But I want to answer the issue, why the writ is maintainable. I'll do that.
Yes, please do that first.
Now, please see the prayers in the writ petition.
Yes.
The prayers in the writ petition, prayer C. Writ of mandamus to issue commanding the respondent number 1 to pass, which is RBI, to pass appropriate order and or make an award under the Reserve Bank Integrated Ombudsman Scheme against the respondent number 2 and 3 and such other officers who may be responsible for the illegal freezing of the bank account. Then, Milord, compensation and, Milord, necessary steps being taken. Apart from that, Milord, prayer A, Milord, is for defreezing. And your lordship, Milord, considered this in paragraph 10. Milord, please see, Milord, my lord's order. This is of 9th April 2025. The submission of the bank that the writ petition will not be maintainable cannot be accepted in the facts and circumstances of the instant case. The petitioners have got a banking relationship with Axis Bank, and the right to business directly involves banking transactions. If the bank account and demat account of the petitioners are frozen by Axis Bank unilaterally without any cogent reason, the fundamental right of the petitioners to carry on business gets infringed. So with these findings, Milord, and with, Milord, prayers against Reserve Bank, and, Milord, the Ombudsman order is challenged in this, Milord, it's effectively challenged here. Your Lordship entertain and decides, Milord. Now, three things I want to say. Number one, complainant, my learned friend says, is not a party. He says that if there is a complaint in a demolition matter or some other, Milord, matter, he must be.
Your
treated.
submission is that he is not a necessary party, and that is the reason he is not
No, he is a
required.
party. August agents is a party. Complaint is made by August agents.
Not a private complaint by
It's not a private complaint by him. Complaint made by August agents, signed by him as director.
authorized signature.
When the complaint is made by August agents, then, my lord, he is a director. Subsequently, he is removed as a director. All, my lord, his attempts to get back, my lord, fail. Subsequently, August agents itself, the complainant, comes and files a writ petition in court.
Where is August agent a party?
Petitioner number 1. 2. My lord, what is happening? When he was a director of the company, he uses the name.
Do not listen.
Yes, I'm not listening. My lord, when the petitioner, my lord, was under he was a director, he made a complaint. The company, yeah, right, Mr. Gupta. Company made a complaint. Company is August agents. Subsequently, my lord, Daga Damani, etc. go. One is removed, 2 are not re-elected, they go as directors. That, my lord, is brought into question before NCLT, no order passed. Daga Damani permanently out. Then the company comes back, my lord, the complainant now comes back to court and makes a writ petition saying that why is ICICI defreezing my account? Axis defreezing my account. So he's very much, he did not make complaint in personal capacity. He made it as director, authorized signatory. Not otherwise, for whatever a removed past director has done, I have to now make him a party to everything I do. It's totally contrary to company law. This is number 1. Number 2. So what does he say? He says, I was, let's see who's the petitioner, Lord, it's August.
Is the complaint annexed to the
Lord, this is
application for intervention?
Axis Bank put it on record. This is the complaint. Before the division bench, it's referred to in the order.
It must be there in the intervention application? The complaint?
No, I don't think so. If I may
How
be
can it
corrected.
be?
Hey, call us it.
In
Intervention.
the intervention application,
Nah,
the complaint
it's
is
not
not.
there. No, not there. I'll give him a copy of his complaint. Of my complaint, signed by him.
This is not suppression.
Lord, Mr. Bachawat is here. Okay. Oh, he's for Mr. Bachawat's for the holding company.
100%
Mr. Mitra is my senior in the matter. Now, my lord, please see the complaint. Please see the date first. 10th May 21. Please see who makes the complaint. Petitioner number 2. Please see who signs the complaint.
And see this paragraph.
My lord, their clients. And what are they signing as? Authorized signatories. Now, subsequently, what happens? Number 1, these authorized signatories are directors. They are, my lord, removed. Once they are removed, matter is taken to NCLT for regarding removal of some of them. There, my lord, the NCLT petition is dismissed. Matter goes to NCLT, NCLAT, sorry. There is no stay. Appeal not admitted. He is gone forever. MCA records are changed. MCA records show that we are now in control of the company, the present signatories. And he comes and says, I am the complaint. It's wrong.
Now see, read para 1 of his application.
Now, my lord, when he comes before your lordship, he makes a deliberate false statement. He says he's an existing director of the company. In para 1 of his application. This is perjury. Number 2, Lord, see the complaint. Now I want to show the complaint, Lord. It's important. I should have shown this earlier. We like to inform you, such and such, there have been certain disputes in the management of the company with some of its directors, in particular RP Singh, seeking to act against the decision of the board of directors and seeking to connive in such and such appointment of persons as directors and shifting the registered office of the company against the provisions of articles made thereunder, master directions of RBI applicable. We would like to inform you that the subsisting management dispute in the company has also been recorded in the office of the registrar of MCA. This is what I showed your lordship has been demarked also, which they have unsuccessfully challenged. So, my lord, if I may sum up this argument of mine, number one, the writ petitioner number 2 made a complaint represented by its directors, the then directors, who have all been removed / not elected. Attempt, my lord, to bring those persons back have failed up to NCLAT. The complaint shows that there is mismanagement in the company for which management dispute has been marked, that which is why the bank account should be frozen. The management dispute has been subsequently unmarked, and the, my lord, mismanagement allegations have been rejected by NCLT and no order from NCLAT obtained. Now, in this situation, my lord, he can't say that I am a complainant. He can't say that I have a right to be added.
এখানে যে অ্যাপ্লিকেশনটা রয়েছে না ফর ইন্টারভেনশন,
It is 1:30. Is it my lord's pleasure I come back, my lord?
no sir,
I'll
I'm
continue.
waiting. I will
No,
continue.
no, I am, my lord. Absolutely.
I am not
So, my lord,
rising now because as it is, there is a Supreme Court timeline fixed, which possibly has expired. Now, one of the parties will go up and
no, I
make
don't want that.
submission
I-
that
My lord,
the
I'll take 10 minutes
court-
and finish.
yes,
I'll just respond to that
No,
in
no, no.
5 minutes after
finish
that.
it up.
Yes, my lord,
Yes,
I'll
please, let
take
him
less
take 10 minutes.
my lord, less than 10 minutes. I am in
I'll
rejoined.
just respond to that immediately.
This is number one. Number two,
Yes.
the division bench, my lord, says, and I want to, my lord, please, my lord, see the order for just 2 minutes. The division bench says, and I am not on, my lord, the observations. Your lordship will, my lord, consider the matter. Please, my lord, see paragraph 49 of the division bench order. Mat number such and such allowed on contest, thereby setting aside the impugned order dated 19th June, which is the order which stayed, my lord, the decision on merits by your lordship. The learned and that's, my lord, upheld up to, my lord, Supreme Court, the, my lord, decision. Paragraph 50. Learned single judge is requested to take up all the pending applications together by disposing of the recall application and the clarificatory application filed by Axis Bank first and decide on the contempt application thereafter. Now on recall, only issue, my lord, is locus. Locus, my lord, I have explained, is not the complainant, and the status in me, which was used by him to write the letter, he has lost, and that's, my lord, final today. So he can't even claim to represent me.
Complaint not in his personal capacity. So personally, I need to.
The complaint is not in his personal capacity. Now to quickly, my lord, deal with the remaining points. First is, there is a writ petition challenging the demarking as management dispute. I have shown that order to your lordship. There is no order staying, my lord, the setting aside of the management dispute. From 2021 till 2026, my lord, no steps have been taken by him in his writ petition. Number two, my learned friend says he is a necessary party. I say he is not. The complaint not in personal capacity. He has also not shown how he is personally affected by, my lord, this. His complaint is regarding functioning of a company. He's as director, functioning.
Not repeat points.
I'm sorry, my lord. Next is, my lord, we took it to Reserve Bank of India. That's under subject challenge in this writ petition. My learned friend said it's not challenged anywhere. Then, my lord, he says writ petition by private bank. Your lordship, giving reasons, has rejected this argument. And he says, my lord, it's pending in the NCLAT. There are no orders in his favor. My lord, these are my humble submissions.
I'll just respond in 2 minutes, Your Lordship will give me.
My lord,
Just
sir, rejoin.
Lord, I appear for the respondent number 5.
Respondent number 5.
5.
Who is the respondent number 5?
But we are the 100% holding company of these companies. 100% shareholder, these are my subsidiaries.
Shareholders.
These are my subsidiaries. 100%
not the
shareholder.
writ petition.
Not 1%, not 2%, 100%. Now,
Yes.
now not before I get into not the story behind it, but some not very basic points which I need to point out here. One, today your lordship is not hearing the writ petition. The writ petition has been disposed of. There is no writ petition. Your lordship is not considering maintainability of writ petition and other things. That is gone. What is there before your lordship? Not a CAN 1, CAN 2, and CAN 3. CPAN. Or CPAN. So one is Axis Bank's application for clarification. They say we want to comply with your lordship's order passed while disposing of the writ, but I need some clarification.
The signatories are to be clarified.
Correct. Correct. So today your lordship is not hearing the writ petition. They want to say Mr. Ghosh came and say he wants to comply, but he needs some clarification. So Lord, there is this clarification application pending. Next is his intervention application. This intervention application, my learned friend will have to show that he has locus standi to enter in, because I intend to deal with that issue. And third is, Lord, a contempt application filed against Axis Bank. This is what, because Axis Bank has not complied with a subsisting order. These are the 3 applications before your lordship. Now, Lord, let me straight away, Lord, go to the right of these gentlemen who want to intervene. Lord, take para 1 of his application. Just take para 1 of his application. CAN 2.
I am holding the brief of this Insilco agents. Are you with that?
All of them the same.
Same.
All of them the same. All of them the same.
Yes.
Now, my lord, please see this. The applicant numbers 1 and 2 are existing directors. Answer is absolute no. False statement, this would have been their locus standi. Because, my lord, if he is not a shareholder, because I am 100% shareholder, undisputed. There is no dispute about the fact that I am 100% shareholder of each of these 3 companies. And, my lord, I am a public limited company, my lord, with thousands of shareholders. Now, mutual funds are involved, my lord, financial institutions are involved, all of them are involved. Now, these 3 are my 100% subsidiaries. Now, what happened was, my lord, some of these directors, without, my lord, they can't go against the wishes of a 100% shareholder. Against the wishes of my 100 shareholders, 100% not of VTL, which is me, against my wishes, they went and did a couple of things. They filed some litigation, did this, did that, and the other. Now, as far as this matter is concerned, they also wrote some letters to a bank at a point of time when they were directors. This is many years ago. Since then, they have ceased to be directors. They have not challenged their removal in any forum. They themselves have no challenge. So who are they? Not someone who's not a director or an employee or a shareholder. What right does he have to come in and say, look, please continue the freeze on the bank account of that company. He has no right whatsoever. My learned friends have to first satisfy your lordships on their locus standi, their right to intervene. They are nobodies. And Lord, the fact that they come before your lordships with a false statement on oath that they are existing directors. Now, Lord, the records of the MCA show that they are not. They have been removed. There is no challenge. They've been not removed long years ago. There is no challenge. Now, coming with this false statement, Lord, also please see just one more thing from that petition. Verification. Now, Lord, please come to the verification portion at page 40. I am the applicant number one. I am acquainted with the facts and circumstances of the case. Now, Kenny, he was involved in the company many, many years ago. He has gone. Now, let's look at this from common sense. While he was a director, he wrote to the bank saying, please freeze the bank accounts because there is a dispute. He has now ceased to be a director. 5 years have gone by. Can not that account remain frozen because something a erstwhile director wrote? Thereafter, there are any number of resolutions by the board of directors and not AGMs of the company authorizing others to do so. They've written to the bank saying, please allow operation.
All right.
The bank can't decide this dispute. So, that is my second point now. Not one, no locus standi. Two, that complaint, if any, that he has made today is irrelevant after so many years. Third, he has not challenged his removal. Now, does it mean that this bank account will now remain stuck at his instructions? Fourth, he has no court order. Now, who is Axis Bank to say that, look, you people have been fighting. There is some dispute pending. Answer is there is no dispute pending between me and this gentleman, these two applicants. There is no dispute. There is no challenge. They are gone.
All right. This must be over.
What is the issue now? It's boiled down to this.
Now, I tell your lordship, just one last thing. It may shorten things for your lordship also. So now, my lord, his right to intervene gone, which leaves the second application, my lord, clarification by the Axis Bank. Now, my lord, please come.
He has not yet placed. He has not yet placed.
Maybe I am just pointing. He can move it. Lord, he can move it. I have no problem. I'm not stopping.
Looking at only the intervention.
Lord, it's linked. It's linked. It's linked. What I'm pointing out is, Lord, first part is, Lord, my learned friends have no locus standi. Writ petition has been disposed of. Order has not been recalled. All that is left today
Yes,
is,
I get it.
Lord, just one para. Just one.
Clarification, I'll hear it after I finish off with the
Just one para, it's connected. I'll just not, if your lordship doesn't mind, I'll take only that 30 seconds. Not in his application, not can one, which is pending. Not if he again chooses to wait and watch to see the outcome of his not colluding parties coming in, he should have moved it.
Yes, I am not.
I see. Very well.
He wants to submit. Let him submit. But then,
Lord, I will make my submissions once he moves it. But please see what he wants. He wants to comply.
It is his application.
Lord, very well.
Oh, he should move it.
Very well.
Right.
Lord, without getting into if your lordship wants me not to, all I'm pointing out is he also wants to comply with the order which is passed by your lordship. That's all. There is no scope. Hey, listen, yeah.
I'll hear you later on. It's only the intervention that I'm hearing.
Very well. Oh, so, like I said, today your lordship is.
I understand. Who is going to sign?
I'll just respond in 2 minutes to the arguments that have been made. But first argument is somewhere with regard to maintainability. I'll end with that. The company had made the complaint. The company is the petitioner number 2. I was nobody. This is not the writ petition case. Your lordship has seen the order. 9th of April. Your lordship succinctly records what was argued then. I'll just place that once.
No, do not place any
Bank
further.
lodged by the erstwhile directors. No, my lord, submissions are being made, which is absolutely contrary to record. One more aspect, your lordship will please make a note of, my lord, the writ petition, paragraph 12. It records that I am a paragraph 12 of the writ petition, which your lordship will find at page 85. It records me as a delinquent ex-director of the petition number 2, at whose behest this management dispute was marked.
All right,
Paragraph
please
12, paragraph 20. Last, my lord, one more thing. Your prayers have been shown in the writ petition to show that there are prayers against that banking ombudsman, therefore RBI is involved. Your lordship, while deciding, my lordship will kindly make a note of only one thing. The Supreme Court judgment deprecates this. This Supreme Court judgment showing RBI circulars, RBI scheme deprecates this practice. That your lordship will find at 9, paragraph 9.
Can two ta dekhi to can two. Eta.
Subparagraph 3. 9, subparagraph 3. Although
All right, I follow.
that much. The no.
An application for intervention has been filed by 3 applicants claiming themselves the applicant numbers 1 and 2 claims themselves to be the existing directors of the petitioner number 2 company. The applicant number 3 claims to be the existing authorized signatory of the current account and the demat account of the company with the Axis Bank. Stop. The writ petition paragraph. The writ petition was moved by তিনটে না চারটে মামলা আছে, ঠিক আছে? তিনটে মামলা আছে, ঠিক আছে? চেঞ্জ হবে শুধু কোম্পানির নামগুলো. The writ petition was moved by one of the directors of the company being the petitioner number 2 company. Now, the writ petition was moved by the director being the petitioner number 1 and the company, the petitioner number 2. ঠিক আছে? Yes, yes. The recess period will be over. You all can leave.
No, I'm not going to eat. I have something fixed at 2 in Alipur. I'll have to just.
You all can leave. You all can leave. No issues.
No, my lord,
Whoever wants to stay can stay. If anyone has some work, can leave.
Please,
no
Lordship
issues.
will not.
No issues.
Great.
আমার সাবমিশন কমপ্লিট সব ও একটা গাছ দেখেছো
Yes. The applicants claiming themselves to be the existing directors of the company has sought for intervention in the writ petition alleging that the entire dispute in the writ petition arises out of a complaint lodged by them. Stop. Submission is that at the time of hearing of the writ petition, an opportunity ought to have been given to the complainant to place their case. Stop. Not providing any opportunity to the complainant would amount to violation of the principle of natural justice. Stop. It has been submitted that there are disputes in between the directors and the management of the company. Stop. The issues were pending before NCLT, which has thereafter traveled up to the NCLAT, and the appeal before NCLAT challenging the management dispute is still pending consideration. Stop. The writ petition has been filed upon gross suppression of material facts. Stop. The same amounts to fraud being played on the court, and the order passed by the court ought to be recalled. Order passed by the court disposing of the writ petition ought to be recalled. Stop. The writ petition ought to be heard in the presence of the applicants after permitting them to be added as parties therein. Stop. Paragraph. A further issue with regard to the maintainability of the writ petition against the Axis Bank has also been raised. Stop. Submission is that the writ petition will not be maintainable against the bank, as the same is a private bank not discharging any public function. Stop. Paragraph. Prayer has been made to allow the application for intervention, and thereafter decide the writ petition on merits. Stop. Paragraph. The aforesaid submission of the applicants have been opposed by the learned counsel representing the writ petitioners. Stop. It has been submitted that the applicants do not have any locus standi to move the locus standi to be impleaded in the writ petition. Stop. The applicants are no way connected with the company in question. Stop. They are no longer the directors of the company. Stop. The dispute with regard to management has already been unmarked by the registrar of companies. Stop. The NCLT has passed order against the applicants. Stop. No order has been obtained by the applicants from NCLAT. Stop. Paragraph. It has been submitted that at the time of consideration and disposal of the writ petition, the court decided the issue of maintainability of the writ petition despite the allegation of the writ petition not being maintainable being raised by the bank. Stop. Stop. It has been submitted that the applicants were at one point of time, the directors of the company and no complaint has been filed by the applicants in their individual capacity before any authority. Now, কি বললাম? Stop. The complaint was made on behalf of the company, which is the writ petitioner number 2 in the writ petition. Stop. Prayer has been made to dismiss the application seeking intervention. Stop. Learned Senior Counsel representing the respondent number 5 in the writ petition submits that the said respondent is the 100% shareholder of the company. Stop. The respondent number 5 strongly opposes the application seeking intervention. Stop. It has been submitted that the applicants are in no way connected and are related to the company at present. Stop. Any complaint lodged by them while they were the erstwhile signatories and directors of the company cannot be permitted to be acted upon for an indefinite period of time. Stop. The business of the company is being seriously hampered due to the action taken by the bank to freeze the bank account of the company, for which the writ petition was moved, seeking defreezing the bank account. Stop. Paragraph. The respondent number 5 specifically submits that the applicants do not have any locus to be added as parties in the writ petition. Stop. They are neither necessary or proper parties to be heard at the time of deciding the list in the writ. Prayer has been made to dismiss the application seeking intervention. Stop. Paragraph. Upon hearing all the parties and on perusal of the documents on record, it appears that the very complaint which the applicants hold on to have been filed before the bank has, for reasons best known, not been annexed to the writ petition. Stop. The reason for not annexing the complaint but setting out the contents of the same in the application is not known to the court. Stop. Copy of the complaint has been handed over to the court by the learned counsel representing the writ petitioners. Stop. It appears therefrom that the complaint was made by the company, signed by the signatories at that point of time. Stop. The paragraph. The the company information downloaded from the Ministry of Corporate Affairs, available as on 1st of July 2026, has been placed before this court, wherefrom it appears that the applicants are not currently the directors of the company. Stop. Paragraph. The averment made in the application seeking intervention that the applicants are the existing directors of the petitioner company appears to be an absolute false and incorrect statement made on oath. Stop. The applicants may have been holding the directorship at some point of time, but the date when the writ petition was moved or the application seeking intervention was filed, comma, they were not the directors of the company. Stop. Paragraph. There may have been disputes between the directors of the company, comma, there are judicial fora where such disputes are to be adjudicated. Stop. The said dispute is not a matter to be decided in the instant writ petition. Stop. Paragraph. The court is of the considered opinion that the applicants, comma, at this stage, comma, do not have any right to intervene in the writ petition filed by the company and one of its directors seeking for a direction upon the bank to defreeze their bank account. Stop. Next. The court does not find the applicants to be the proper or necessary parties for adjudication of the list. Stop. The applicants may agitate their grievance with regard to their status as directors before the competent forum. Stop. Next. In view of the above, the application seeking intervention cannot be allowed. The same stands rejected. Can two. The paragraph, the application seeking clarification and
There's a contempt.
There's a
Contempt.
and there's a recalling by whom?
Can two.
Clarification and contempt.
It's not a recalling. I want to comply with your lordship's order. One with a clarification.
Yes.
And with the
Intervention and recalling was the same application.
Can
Intervention and recalling.
is can two.
Can gets dismissed.
clarification to comply.
Acha.
Can one.
Can one has been filed by the Axis Bank seeking clarification of the order passed by the court on 9th of April 2025. Stop. What is the clarification that you seek?
The kindly takes lordship's order.
Yes.
Paragraph 11.
Yes.
As the pro forma responses provided indemnity in respect of the accounts held in Axis Bank according to the bank account and the demat account of the petitioner, there's a rider to it. Subject to depositing an indemnity bond as per the norms of the bank. So bank will give him the bond. Will be section is section 124, read with section 125 of the Contract Act. As per the norms of the bank, either by the petitioners or by the pro forma respondent. This is lordship, what has lordship has given. Now, will kindly, I will say that. So,
Yes,
lordship will remember when lordship was sitting in the other court, that bank had gave the format. They will not change unilaterally the format and wanted to put in certain things. If your lordship, kindly will not take page section 124. I'll come to that later. This will go on with a contract of indemnity is defined. A contract of indemnity, a contract by which one party promises the other party to save the other from loss caused to him from the conduct of the promisor or by the conduct of other person is called the contract of indemnity. With an illustration, A contracts to indemnify B against the consequence of any proceedings. like my lord, Mr. Chatterjee's client may initiate proceedings against me, which C may take against me in respect of certain sum of rupees 200 or any other sum. This is a contract of indemnity. So, my lord, this language used to give an indemnity either by the petitioner or by the pro forma respondent. But it's going on, my lord, this side, that side, like a shuttlecock, my lord, is going on. Now, my lord, in the clarification, prayer A, if your lordship please.
That is incident.
Prayer A.
With regard to the details of the authorized signatories to be allowed.
But if lordship doesn't want anything, my lord, writ petition has a resolution. Has a resolution at page 60 of the writ petition. Kindly have a look at page 60. Kindly have a look at page 60. I have to comply with the order. Page 60, this indemnity, no indemnity. Page 60, lordship will direct me to act as per that resolution.
The new ones or the old ones. He wants to be told that.
Lordship will direct and decrease. That's his resolution he has given me. I'll act.
Last one.
21, page 60. That's your resolution. Your three names. But you can match the names I have given.
10th May.
I give to my learned friend a copy also.
So do that.
This was the old.
He
new. He knew this was not print.
তুমি
এইটা
নিউটা করো হ্যাঁ ঠিক আছে yes first time
Sushil Daga, Krishna Damani and Vinod Sharma.
The new ones are the new signatories Rakesh Puri, Aditya Saraugi, Manoj Kumar Mehta, Vinod Kumar Khasare and Miller, Rakesh Puri, etc. There are two accounts, current and Miller, current account and demat. Page 60 Miller covers.
The application for intervention were made by Daga, Damani and Sharma. That has been dismissed.
Yes.
So what remains is this.
Yes, page 60, lordship will direct.
Page 60 in my brief is not matching with yours.
Of the writ petition.
Yes, of the writ petition.
6088, lordship is taking 6.
No, I'm looking at 6112. You are no one to say now. I have dismissed.
Let me clarify it.
The first line, but the second line clarifies.
There is an appeal court. So I'm not hearing. You are out from the scene now.
Give me 1 minute. I give the correspondent page number.
Yes.
I'll help you.
Annexure.
Annexure P.
P3 Miller.
P3, I can see certified true copy of the resolution passed.
That is the one. That
The
is
page 61, certified copy, RP Singh.
Yes.
Yes, that's the one.
That's the one. I will comply with it.
Great.
Please to comply.
Yes. Let that statement be recorded.
Indemnity part goes. No. Indemnity he is not willing to give as per indemnity.
By virtue of the dismissal of the application for intervention, they will file the.
You don't need now.
That order remains.
Para 11.
Paragraph 11 remains.
Yes, indemnity, Miller. He has to give me an indemnity.
We have given him already.
No. He has not.
Oh, you have made certain changes or something.
Miller, to obviate that, lordship kindly, Miller, to obviate that, kindly records page 60, it solves all time to come. I am protected by the. Lordship records it, it's not necessary. Page 6, I'll comply.
Yes, I have no objection.
Well, you may not have any objection. The court may have objection. Why won't you file an indemnity?
We have submitted.
No, and not as per the bank's term.
Yes, there is a banking laws. According to that, you have to submit the indemnity. Why don't you submit that?
And then my content starts from that day, paragraph.
Miller, have you?
Come on the next day.
Yes.
Miller, I'll come back.
Miller, next Thursday
I'll keep it.
He says.
In the meantime, an appeal will come and you see what happens in the appeal court.
Lordship will pass a direction.
I will not pass a direction.
This will be for all times.
No, sorry, sir. There is an order, paragraph 10 or 11, which you have mentioned that will remain.
Yes.
And the indemnity, if required to be filed, they will file it.
Miller, may I suggest this?
They will.
Miller, may I suggest this? I have already. I have filed an indemnity in terms of my lord's order.
It is not.
You say it is in terms of the court's order. The bank says it is not.
You have changed.
Now, if you come on the next day, see what are the changes that you've made. The bank is not accepting, and what can be done.
By the
And in-
respondent number 5, I wanted, Mr. Mitra said, yes, it will be by the respondent.
is
number
either
five.
by-
Whatever is
Then
there in the order, that order remains.
on the discretion of the
It's
bank.
only the
Yes,
recalling
because
application. He will have
there
the
are-
application for
Copy
clarification and the contempt application.
বসে করতে হবে, বসে করতে হবে।
ঠিক আছে।
The language of 130
আরে দাঁড়িয়ে হবে না।
Stuff. An application
Bear with me.
for contempt
8-5 দেবে না।
filed by the petitioners
Either company
is also pending. Stuff.
company or
Both the applications will be taken up.
Main company from
Next Thursday is
Lord,
30th.
Milord,
there is a problem.
Is that-
may I take a last try, Milord?
Accusation that it was either by the petitioner or by the it was volunteered by them or by the respondent number 5. Bank wants it from the respondent number 5. Now they say respondent number 5 is not.
Will not
We-
give.
we- no, we have given on behalf of the petitioner.
No, I want
have submitted
or
with-
they volunteered, they say no.
Milord,
By
The
behalf.
order is either
By behalf.
either
Why
by the
is the
company.
company coming up?
Milord, company is
Company is
here.
given.
Milord, I'll tell you, may I just take
As a pro forma
1 minute to solve this problem?
accepted the indemnity bond in respect of the accounts. They have accepted, let him give that.
Milord,
Company or
Milord, may I,
Next day,
Milord, I can,
solution.
Milord, I can give a solution here and now.
Speak to the bank.
Milord, the problem is that they say that these new signatories who are there, if those people, Milord, those mentioned in the board resolution, if they sign, the new ones, if they sign, we want an indemnity. But now, after the turn of events, after the dismissal, non-marking, etc., they may not need. We are still willing. We have still submitted an
Very
indemnity
well.
of the
Both
petitioner.
please take instruction. Come back next Thursday.
Otherwise, what should
Very well.
Next Thursday.
We'll come back.
pro forma respondent said that they will.
There is a Passover matter personal appearance. Is the contemner present? Who was the contemner? Eta.
Lordship, I have the report ready. I've served
Yes.
a copy as well. He has received it on WhatsApp because he was at that time he was in Guwahati High Court, Lordship, and I had called him. So today he has physically received it.
What is it? What is the Pradhan doing in the Guwahati High Court?
No. The Pradhan is not doing anything, sir. Lordship, the petitioner's learned advocate, I had called him to
All
sign.
right.
He was in Guwahati.
Did you get a copy?
Yes, ma'am.
Has the order been complied?
Order not complied, my lord. This is
Not
the form of
complied.
report in with an application of the contempt violation. My lord, kindly see page 8.
Let me have a copy.
Lordship,
There is no reason order was passed, my lord.
Lordship, page 22, my order.
Page 22.
Lordship,
What is this?
starts from page 21, Lordship. This is the kind of resolution that was passed. The petitioner was also present in the meeting, Your Lordship. Both the parties were present. The Pradhan was told by the petitioner and the opposite party, stating that there is already a pending title suit between the parties about this particular property. That is the reason they are writing, Your Lordship.
What does the title suit have got to do with an unauthorized construction?
He says it is a disputed property. Kindly reads, Lordship, page 22, the order
Is
that
there
he has
any
passed.
finding that the construction has been made in accordance with any plan sanction?
No, she's stating it is not in accordance with law. There is no sanction plan. There
Then
is
what
no sanction.
remains?
Lordship,
Let the title dispute be decided by the civil court. What the Pradhan has got to do with the title dispute?
Nothing, Lordship. She is admitting that it is not in accordance with the law. None of the properties
Where is
have a
the order
sanction.
passed?
Lordship, page 22. This is the condition of the order passed. Your Lordship, in Bengali, she has written, if your Lordship directs, I
Madam,
shall
this
read
is
through.
not an order.
I agree, Lordship. This is not an order, and I had told her, Lordship, to write it in accordance with my format, Lordship.
Same order passed in the morning.
Lordship, gives me one opportunity, Lordship.
Yes. Hmm. Stop. It appears, just act a line. It appears therefrom that the Pradhan uh, failed to act in accordance with the order passed by the court. No observation to the order আছে.
Lordship, may I be given an opportunity to file a better order, Lordship, a reasoned order as per the order dated 5th February
Check up the order that will be put up in the server. All right. I permitted someone to mention in the morning. Yes. Is your other side here? Who is your other side? Yes. This matter is being mentioned on repeated occasions for not having been complied with.
My lord, it's not that, my lord. I remember from the order sheet, my lord, will find that there were two persons, my lord, who are not there in the fray, neither in the writ petition nor in the contempt. They were not. Now the allegation has been shifted from writ petition that portion. His portion in property remains, my lord, vacant. Besides the portions, my lord, there are some constructions. Still then, pursuant to my lord's observation, my lord, inspection was caused in presence of all the parties. Then, my lord, they were called on, and ultimately, my lord, a proceeding under 400 subsection 1 has been initiated. The matter is pending before the special officer building.
And is the petitioner aware of all these facts?
Yes, notice was there. Notice for hearing was there.
Kindly see the previous order.
Notice-
Lordship has directed
Not
that.
it-
No, not the previous order. These happens after that.
Yes. No, I
Which is the
understand.
item number?
Lordship, you are 241.
File দেখান তো 241
I can show that the notices were given to them. They have received the notice. Yes.
No
They
hearing
have.
notice
Yes.
has been sent to the petitioner, Lordship.
Your lordship, kindly see.
ওইদিকে আছে।
These are the notices, my lord, copies of the notices. I do not.
All right, you give a copy to your learned friend. Next Thursday, it will appear at the top. You also take instruction in the meantime as to whether any notice has been received by your client.
Even today, my lord, I have taken an instruction. My lord, the special officer building, upon hearing, my lord, was pleased to direct the department of the corporation to furnish details and sketch maps.
When is the next date fixed?
Yes, my lord.
When is the next date?
My lord, it's not there. It's from the.
All right, you take instructions. Next Thursday, it will appear. Next Thursday. ডেকে দিন।
তোর মক্কেলকে জিজ্ঞেস কর, বাজে কথা বলছে, দেখে নে কেন পাবে না,
একটু না
কেন পাবে না?
নোটিশ দিলে নোটিশ পাবে না, কেউ মুখে এসে বললে তো মুশকিল।
কোনো হিয়ারিং এ নোটিস রেসপেক্টফুল লর্ডশিপ এসব
Madam, for the petitioner. They have served the copy of the order, my lord. Whenever the order passed, my lord, is order passed, my lord, in violation of my lord's order.
Yes.
They have submitted an affidavit, my lord.
Huh? Affidavit of compliance. Has it the order been complied?
Order has been passed, but in violation of my lord's order.
What is the violation?
My lord, kindly come to my lord's order at page 86.
It is the order dated 1st of October 24.
My lord.
Yes. And what is the compliance?
Compliance.
Mal municipality?
Yes, my lord.
What is the compliance?
Compliance at page 4. Page 16, my lord, of the affidavit.
Page 16.
No, no, page 17, my lord. Sorry. One of the factual findings, my lord. Point A. Both the complainant and the private respondent possess what appear to be duly sanctioned building plans for their respective constructions. These documents were produced for verification by the inspection team. Point B, my lord. Notwithstanding the existence of sanctioned plans, the undisputed physical fact is that there is no statutory open space or setback actually maintained between the complainant's one-story building and the private respondent's three-story construction. This is their finding, my lord. Before that, my lord, at page 16, the private respondent has raised an objection, my lord, allegation rather.
What is after this factual finding? What is the conclusion?
Conclusion, my lord. The conclusion at page, starting from, my lord, page 19. The bottom, my lord. May I read one? The representation dated 15/7/2024 submitted by the complainant Sri Ramashankar Prasad stand disposed of by this order as this authority is unable to make a conclusive finding on the merits regarding the allegation of unauthorized construction at this stage. It is held that a final determination as to whether any construction by the private respondents is authorized is at present not possible. Such determination is directly contingent upon the resolution of the underlying and fundamental boundary dispute subsisting between the parties.
Who's there for Mal municipality?
Your Lordship, I am appearing for the matter.
Oh, you are there. Yes.
Lordship, this is the original affidavit of complaint.
Yes.
As
Who
per-
has written this reasoned order?
Your Lordship, this is being signed by the chairman Mal municipality.
Who has prepared it?
Lordship, that I'll have to take instruction since the direction was upon the chairman of the Mal municipality. The order has to be his.
Direction was upon the board of council.
Yes, it cannot be the chairman individually. Chairman does not have individual
Board of Council.
authority. Where is
This
the
one-
board of councillors? The order sheet is by the chairman. Where is the approval of the board of councillors? Huh? First.
Your Lordship, in that respect, I'll have to seek instruction.
And second, despite a finding that there is no statutory open spaces,
Not sure.
the conclusion is that the municipality cannot take a decision.
Lordship, I'll come back to that. Your Lordship, at page 10, paragraph number 8 of your Lordship's order, the aforesaid respondent shall restrict the consideration of the representation with regard to the unauthorized construction only and not to enter and decide any private dispute of the parties regarding right, title and interest in respect of the aforesaid land. Now, your Lordship, while passing of the reasoned order, your Lordship, if I may refer to page 17.c, during the course of inspection as well as throughout the proceedings, neither the complainant nor the private respondents were able to produce any conclusive title deeds, land records, records of rights, or an authoritative.
Were you required to look into the title deeds?
Your
You are not
Lordship,
required.
there is a common boundary wall in between the private respondent and the petitioner's properties.
Right.
The case of the municipality is that both of them have got authorized plans.
Yes.
Now they haven't left the statutory
Yes.
gaps. Now, from where the petitioner's land starts and from the respondent's land starts, that could be ascertained as per this report only after pursuing the title deeds and everything. Now the private respondents haven't participated at all in the hearing. Even the petitioners were required or asked to provide such documents. No such documents were provided. At least no such denial or anything as such has been brought to record before the municipality. Now, considering such circumstances, I may assume what is going on in my Lordship's mind, that demolition or if any step is to be taken against both the parties then.
Take it. Who's stopping you? Is there any order that whoever
Lordship.
comes to court is
Definitely.
sacrosanct? It is not so.
Definitely.
It may be that the petitioner is also
Can
guilty
be.
of making unauthorized construction.
Can be.
Take steps. But first of all, where is that order of the Board of
Your Lordship,
Councillors?
that has not been annexed here with.
Annexed? Is
That
it
has,
there?
I'll have to take further instruction with respect to that.
Please come.
My lord, one more submission, my lord. My lord, the order is with regard to only my side, my lord. The other three sides, no mention about
Nothing mentioned.
nothing, my lord. Not a single word. But in my
At
representation, it's stated-
peruse the affidavit of compliance filed in court by the contemner. Stop. It appears therefrom that the order allegedly in compliance, the order passed by the authority allegedly in compliance of the direction passed by the court is signed by the chairman Mal municipality. Stop. According to the provisions of law, comma, the order relating to unauthorized construction has to be passed by the Board of Councillors of the municipality. Stop. In the present, now from the affidavit of compliance, it appears that the order has been passed by the chairman Mal municipality and there is nothing on record to suggest that the Board of Councillors were at all involved in the decision-making process. Stop. Such action of the municipality is contrary to law. Stop. Paragraph. The affidavit of compliance filed by the contemner accordingly cannot be accepted. Stop. Hearing of the contempt application stands adjourned till 17th September 2026. Stop. A fresh affidavit of compliance shall be filed on the adjourned date. Stop. The order passed by the court shall be strictly complied with by the contemner. Call the next matter.
Order has been complied.
Very well, order complied.
Order complied.
Disposed.
Your Lordship, dismiss the
Disposed.
Disposed.
Three.
My lord, item 3 I am for petitioner, my lord. My lord, after passing my lord order, my lord, after passing order, my lord, on 17th July 2026, my lord, I received the mail from the Mal municipality. My lord, by there, my lord,
this is what, my lord, I have annexed.
Original. Oh, you've annexed. File it. Oh, file go to the
I received, my lord, through mail, my lord. I just indicated, my lord, 3 para, my lord. First paragraph.
I have heard about what institutional fraud that I find from the documents, my lord, is horrible.
And
you are appealing for
alleged
fraud.
and my lord, alleged funds are also associated with them.
Who is associated?
My lord, present chairman.
Is also associated.
Yes, my lord.
There have a my lord 120 crore fraud with my lord small area. And my lord, we are filed my lord appeal application after my lord direction my lord from the honorable court. My lord,
The present chairman is also involved.
yes, my lord. The allegation also my lord against him, my lord.
What is the name of the present chairman?
Utpal Bhaduri.
You mentioned only chairman, not the name.
My lord, the order is, my lord, that he will be personally present.
Huh.
That's what, my lord, I believe, my lord, there is no rule has been issued.
All right, is he present?
Yes, my lord, he is present.
Where is he?
Yes.
Uh-huh. Officer in charge, Mal police station was directed to ensure presence of the chairman.
One police
Has all brought him. Why did he not appear on the last?
My lord, I have explained that, my lord. Mali, kindly takes, my lord, paragraph 4 onwards. Kindly takes paragraph 4 onwards, my lord. In the compliance report which I have filed, my lord. I have specifically mentioned, my lord.
Yes.
Kindly see, my lord, state that the content application so and so was served upon the office of the Mal municipality pursuant to the direction. However, due to an unfortunate, unintentional administrative lapse, lack of coordination, and a communication gap within the municipal office, the said contempt application and the order of this honorable court were never placed before me for my attention or necessary action thereafter. That as the said document were not brought to my notice, I was completely unaware of the pendency of the contempt proceedings. Consequently, no representations could be made on my behalf when the matter was taken up for hearing on 7th May 2026, on which date this honorable court was pleased to issue rule. That is not correct. Next, my lord, I further state that with utmost humility that the contempt rule returnable on 25th of June 2026 was also never served upon me, and I remained entirely unaware of the proceedings and the directions of my appearance. Then I came to know about the instant contempt proceedings for the very first time only upon receiving the order of this honorable court dated 25th June 2026, which was served upon me personally by the officer in charge, Mal Police Station, directing me to ensure my presence before the honorable court on 23rd July 2026. Thereafter, my lord, he has taken steps against the persons concerned who has, my lord, done all these mischiefs, my lord. A disciplinary proceedings has been initiated, my lord, and in the meantime, yesterday, my lord, 6 persons has been arrested by the police. I have that FIR also.
On what is the allegation against those 6 persons who were arrested?
They have, my lord, issuing false documents to the persons. Work order, no tender has been made, my lord. In the instant case also, same thing has been happened. In the office, my lord, there is no record of the document which has been annexed with the writ petition. There is no document with regard to the tender, and, my lord, any document, nothing.
And these documents were issued at the time of the erstwhile chairman.
Erstwhile chairman. And, my lord, may I just, the allegation against that is in that nature, my lord. My lord, this is the FIR has been drawn yesterday, and a day before yesterday, my lord, on that basis, my lord, 6 persons has been arrested, out of which, my lord, 2 and 3 persons, my lord, who has not communicating him the order of his lordship's, my lord, are involved. Kindly takes that FIR, my lord.
My
What is the matter about? You want payment?
Yes, my lord. My lord, after passing order,
In
my lord,
respect of some tender?
work order, my lord.
Work order?
I, my lord, supplied the goods. There have acknowledgement. Kindly see my,
all right,
my lord, kindly see my
and in
contempt
the,
application, only page, my lord, only page, my lord,
the
2,
report,
3
my
page,
lord,
my lord.
of compliance.
Kindly takes, my lord, page 8, lordship, once, page 8.
And my lord, kindly, my lord, see his, my lord, order and my lord, false statement before your lordship. Kindly see, my lord, first, my lord,
page 8,
only 2, 3 page, my lord. My lord, I also annexing in my contempt application.
1 minute, page 8. What?
Lordship, kindly see. 1, it is found that the work order cited by the petitioner, namely so-and-so, memo dated so-and-so, which form the very foundation and sanquan in the petitioner's claim for payment, are consequently absent from any official file, record, or register of Mal municipality. No such documents are traceable or available within the formal municipal record keeping system. Thereafter, the exhaustive review of the issue and dispatch register of the Mal municipality for the period in question reveals no entry corresponding to the alleged issuance of the two aforementioned work orders either to the petitioner or to his business enterprises. The absence of any such entry leads to the categorical interference that these documents were never officially issued or dispatched by Mal municipality. Next, no record whatsoever has been encountered of the intimation or conduct of any lawful procurement process, whether by notice inviting tender NIT, notice inviting quotation NIQ, or any allied form of public tendering in respect of works said to be described in the disputed work orders. The absence of such process is especially striking given the substantial financial value of the claim. Next page, my lord. There is a total absence of any resolution or recorded decision by the Board of Councillors of Mal municipality, nor does the record evidence any trace of administrative or financial approval from any competent or empowered authority, either sanctioning these works or authorizing the issuance of the alleged work order to the petitioner. The measurement book.
All right, I got it.
My lord, in respect, my lord, I only take, my lord, few minutes. My lord, kindly see my contempt application, my lord, page 94.
You have a copy of
95,
the writ petition?
Yes, my lord, I also, my lord, annexing in, my lord, contempt application because I know, my lord, this fact will be happen.
All right.
That's therefore, my lord, I annexing the document.
You annexed in the
Kindly
contempt.
see, my lord, page 94, 95, 96 and 97.
94, 95, 96.
My lord, received stock book registered, page number 40. Next page, stock register book, page number 40. My lord, there have a
94 is
94,
Mittal
95,
Trading
my
Company.
lord.
95 Mittal Trading
Kindly see,
Company.
my lord, received stock registered book, page number 40. There have a recorded, and my lord, after
Who
passing,
have recorded?
my lord, the municipality officer.
Municipality officer.
Yes, my lord, after passing this order, my lord,
They have
All
these,
the
all
present
these persons
chairman,
has been
the
arrested.
present chairman, he burning and destroying the document. That's therefore, my lord, we filing the appeal application.
That
before
is
honorable
not
court.
the case, my lord.
And well, now, my lord, they are
the
producing
petitioner
the false.
alleges that
Petitioner is also hands in gloves with the previous my lord chairman. I
He
believe
was, my
so
lord,
it
he was,
appears.
my lord, vice chairman that time.
he was vice chairman.
Yes, my lord. He know everything. And not only, my lord, kindly see, I give only one example, my lord, in comparable cases. My lord, board of
The petitioner alleges that payment to the tune of rupees 1 crore.
1 crore, my lord.
কত বললাম একটা বেশ 1 crore 1,14,49,771 ঠিক আছে is due and payable by the Mal municipality on account of goods supplied by him. Stop paragraph. The present chairman of the Mal municipality was serving as the vice chairman.
Yes, my lord.
Of the municipality at the time when the goods were allegedly supplied to the municipality. Stop. Learned advocate for the petitioner submits that all the goods were received by the representative of the municipality, and the erstwhile chairman was very much aware of the entire incident. Stop paragraph. It has been alleged by the petitioner that the present chairman is deliberately burning and destroying records of the municipality so that the claim of the parties cannot be proved. Stop. Paragraph. An affidavit of compliance has been filed by the present chairman of the municipality, who is personally present in court and has been produced in court by the police of the Mal municipality, Mal's police station. Stop. Paragraph. A cursory glance at the affidavit of compliance and at the order of the chairman of the municipality dated 17th July 2026. Na cursory glance na. Paragraphs of the order dated 17th July passed by the chairman of the municipality has been placed before this court by the learned advocate representing the contemner. Stop. It is evident that there is allegation of fraud being played. Stop. Specific submission of the municipality is that there are no documents traceable with the municipality in support of the goods supplied. Stop. There is no notice inviting tender / notice inviting quotation for supply of the goods. Stop. Paragraph. Upon hearing the parties, it appears that an issue with regard to huge defalcation of funds have been made out by the municipality, and the petitioner also supports the same. Stop. Both parties submit in court that there has indeed been gross misuse of public fund. Stop. Paragraph. In view of the submissions made, the court is of the opinion that an investigation is required to be conducted to ascertain the extent of misutilization of public fund. Stop. The court accordingly directs the Superintendent of Police, Jalpaiguri, to conduct a special constitute a special investigation team comprising of efficient officers to inquire and investigate into the allegation of misutilization of public fund. Stop. The SIT to be constituted shall physically visit the municipality to inspect records and take evidences from all persons whom the team will feel necessary. Stop. The current chairman, who was the erstwhile vice chairman, and the erstwhile chairman of the Mal municipality shall be brought into the fold of investigation. Stop. A comprehensive report with regard to the funds of the municipality starting from the period 2020 till the current period shall be placed before this court on the adjourned date. Stop. All the parties are directed to cooperate with the process of investigation. Stop. Let a preliminary investigation report be placed before this court on 8th October 2026.
No, one line may be added, Milord. He has said, Milord, the record has been burned, Milord. That has been disputed by me, Milord. I have specific instructions from that.
All right.
And FIR is be kept with the record, Milord. That,
আচ্ছা
Milord,
যেখানে
kindly. And on the basis of that, the person is arrested.
সেখানে বলবেন যে an FIR has been lodged by the municipality before the police.
No, not the municipality, Milord. One person who is also Bashob Malakar.
Who is he?
Also he is also a person, Milord, who has been deprived of not making payment.
Not receiving payment.
No, sorry, not receiving payment, Milord. So
Achha.
he has made a complaint on the same tune.
A complaint has been lodged by one of the claimants of fund from the municipality, relying on which 6 persons have been arrested. FIR number ta diye deben to. FIR number ato dated ato has been registered and 6 persons have been arrested. Let us see.
Lordship. I'm grateful much.
My lord, it is expected that my lord will not sit again.
My lord, don't believe my lord.
It's a long time.
It is not for me. My officers have to be left for some time at least.
One line,
My lord said.
Now, Milord, he has personal, let the personal appearance of this. Milord.
Personal appearance dispense with for the timing.
Grateful, Lordship.
So clean water will not, my lord, meet the hunger.
ঠিক আছে আর কিছু পার্সোনাল অ্যাপিয়ারেন্স তো নেই
Grateful, Lordship.